All right, it is not 9 yet. But somebody explained to me, as a person who doesn't watch soccer a lot, why is Argentina getting all upset on the field? Take your L gracefully and move on. All right, it's almost, oh, it is 9 o'clock now. I'm going to call the docket. When I call the docket, you need to stand and let me know you're here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. You all may have heard that we're in a jury trial, but the state and defense are going to do closing arguments today. So anybody who wants a trial, who's on the docket today, you will be given your trial. So don't assume that, oh my gosh, this is just going to be reset for another day. That's not what we do on the 187. So when I call your name, stand, let me know you're here. Derek Santos Lopez. Thank you. Mahmoud, he's in another county. Let's see, what county is that, Norma?
Harding.
Harding?
Yeah.
If he's not here by Zoom, then we're gonna have to do a show cause order for Hardin County. Fatima Malara, custody. Jonathan Pomerantz, custody. Dwayne Griggs.
What did I do with this?
Thank
None
you.
of the first two rows.
Oscar Carvajal, custody. Zachary Simmons. Zachary Tanner Simmons, custody. Robert Rustrio. Is that how you pronounce that?
Yes.
Yay. Custody. Juan Mejia. Ricardo Adames. Matthew Caballero. Custody. Kamar J. Derek Santos Lopez. Thank you. You're on the docket more than once. Arnold Stamps, custody. Megan Taylor Popnik.
None of the first two rows. Ladies, and somewhere else.
Samuel Zamaripa. Samuel Zamaripa. Dennis Morgan. Thank you. Antonio Lazard, he's already by Zoom. Robert, thank you. Robert Rodriguez, Jesse Sambrano, Danny Garcia, Max Henry Perez, custody, Helena Catchings, Gilbert Pacina, Jonathan Alcacel or I don't know.
You said it right the first time.
Oh, Alcacel. I never know when the C's are hard. Robert Peevehouse, custody. Amanda Morehouse, Jeremy Cruz, custody. Is Salvador Garcia on bond or in custody?
Custody.
Eric Donnell Williams. Jonathan Pierre Garza. Charles Anthony Pena, custody. Jacob Mike McCumber. Yosette Montoya, custody. Geraldo Castillo. Robert Galvan. Ricardo Adames. Isaiah Gonzalez. Salvador Garcia. Israel Cortez. Eric Cooper, Joe Luis Cantu, Isaac Valle, Dennis Johnson, custody. Noah Olvera. Dominic Smith, custody. James Price, custody. Blake Edward McCloy. Thank you. Jacob Harris, custody. Alicia Ashante Tinoria. Thank you. Were you named after Ashante, the middle name?
Pastor Young.
All right. Kamar Simpson. Victor Mesa. Dennis Johnson. Eric Cooper. Custody. Amanda Morehouse. Custody. And then we start with trial. All right. Attorneys, do y'all know the rules or do I need to repeat the rules? All right. You know the rules? Everybody does? Please don't stand here staring me down when you haven't signed in. We're starting up with our jury trial. We're going to do closing arguments. You can still confer with the state. We have an ad on Gilbert Ramirez. Good morning. Anyone else who came in later, your name wasn't called? What's your name?
It's Julie Pierce.
Julie Pierce.
Pierce is in boy, EERS.
All right. Do you know who your attorney is?
Well, my court date was not till the 26th and they moved it on to the 21st over the last 2 days.
All right, we'll have you check in and they'll see if you're supposed to be here, okay? All right, thank you. Everyone, please confer on this Tuesday.
Judge,
Yes.
I wanted to say I have another court date as well today, a misdemeanor court, and so I was wondering if it's not supposed to be here today, if I can go report to that court.
Well, they're gonna check
Yes,
you in,
ma'am.
okay? No, could you check her right away so she won't be late if she's not supposed to be here?
Oh, 757.
All right, there's a case where they did the plea paperwork.
Just give me a quick second.
Yes, I have.
All right, somebody's dimming the lights.
Maddie. Oh.
You know, it's like Bashan, TGIF Friday, dim all the lights. And today, Bashan, your t-shirt.
That's my
Probation. What are you guys having at probation?
This week is probation officer, corrections officer, role officer.
Because yesterday you were wearing a college shirt.
College spirit day, today is superhero day, tomorrow is.
You know, superhero day. I remember watching X-Men and Jubilee never impressed me. But then when I started reading the comics about Jubilee, Jubilee really has some powers. It's just that on X-Men, the series, she was always as a teenager and get into trouble. The parties here on Gilbert, I'm sorry, yes?
They have to do that, Judge. They have to nerf certain characters to make them not as powerful, because if they were as powerful, the show wouldn't progress.
Yeah.
That's why at the beginning of every movie, Black Panther loses his power, they had time just arrived, Iron Man loses his suit for the majority of the third movie, like they have to nerf them.
Yeah. All right, who's here on Gilbert Martinez Ramirez? Is the attorney here?
Yeah, in my court.
Judge, I think that's either Michelle or Brendan Lopez.
All right. Hi, we're waiting for your attorney. Yes, I have your paperwork. We're just waiting for your attorney. Yes. And you guys gonna have any objections to the charge?
I don't. No objections, Judge. Thank you.
Oh, I'm so sorry.
I can take it to the police.
Thank you.
Please. Twenty 21 CR 52.
I've made an opportunity.
All right, so put it on the docket, have the person brought over.
I don't know.
He's here, Judge.
Oh, he's here. Okay, awesome. What's the cause number?
2025 CR 012153, Judge.
You said 012153.
Yes, please.
Okay. All right, State, if you'll bring that file down for him.
Okay.
All right, thank you.
Like, we're.
Here, talk to me. Yeah, they're busy. What do you got?
State, did you all want to see if the PowerPoint was working? If you all have a PowerPoint?
Ooh. Ooh.
I don't know what this is. Did we do with that? It's false.
Awesome.
9 million.
It's Florida. Be kind.
So, LaShawn,
Yes.
last night, because we were late for trial, I said, you know what? I'm gonna stop and pick up a meal as opposed to cooking. Then I realized I had 2 pounds of shrimp in the fridge.
Oh, yeah, you had to put those.
I had to, and I had to shell and devein. So last night was a shrimp scampi kind of night.
It's crassively. Yes, done. So I think everything should be done.
David,
Cross my
are
T's
you
and
gonna
dot
have
my
any
I's.
objections to the charge?
No.
Okay,
Okay, so let's see.
we'll put that on the record when your client comes out.
Jerry Johnson.
And then Cindy, I'll print a copy for you.
No, they're gonna be closing in about
Oh, yeah.
10 minutes.
You should just.
Yeah, they'll be patient. No, they'll get that one.
But then, does it? Discipline issue.
They're complaining about human inmates on there. It's like, you know, when this, so if I bring 4 up or 8 up, it's not gonna change anything now. We don't have any specials.
Is the printer working over there?
It's up.
Yes, because I just sent 2 things and I haven't heard you know it.
They're also over in Florida.
Okay, thanks.
No, the dog.
Period of revocation, open the court on sentencing.
Like 5 minutes in there. Oh, no, no, I just. Oh. In the court. Why? Then you have to keep it. I don't extra reason. I put extra reason. She's been on her. She was.
No, done with, no, that's. It's just there.
Better say.
Interesting.
Judge Capers,
Yes,
I'm here on an MTR prisoner. Should I just come back later on about an hour or?
yes, they're each gonna have 30 minutes for
Okay.
their closing, and we're supposed to start at 9:30, so you come back and,
10:30-ish?
yes, but if you want to go ahead, and I tell everybody, go ahead and confer with probation.
I've done that and if I talk to the state.
All right, sure.
Okay, cool.
Thank you.
Judge.
Is it one?
It's two.
William. Yeah, that'd be great. And then. Eric Williams? I guess.
Yeah, I know. When we were down there. It's Gilbert, he's in charge. I remember we all did it. His fantasy that the Cowboys did. What am I supposed to do? What am I? She can cuss.
No, we're not. You're done.
See you later. Close in the market.
No, I think.
Well, summarize this.
They waste their time because the jury is already defined.
I'm sure you made it close.
We need to talk.
Yeah.
Yes.
AJ, the back.
The bag.
Yeah.
Speak openness.
Mhm.
It's definitely.
Family for 5 years. I saw that.
Yeah.
It's tough.
I love playing Scrabble with my family.
That's one thing. Yeah.
Yes.
I don't want to, I did want to get up. Oh, really? Okay. I'm surprised, yeah. No, keep going. I'm just. No. What I was thinking. And then as soon as you get out here, sometimes. I saw that last time. Okay, thanks. Yeah, they told me to sleep. I think, yeah, like I said, I'm not trying to. But I. Thanks. It's a new indictment for y'all, but they just wanted me to touch base, because it'll likely be a global. I'll give you. It's innovating and it's pretty He's very severe. Medical documentation about it. He's got a pending follow-up of the MTR, and so I had to that. But yes, happy to share it out with y'all, but I wanted to do a 13-week replacement. And so I can email y'all medical stuff, plain time to get the vision off what. It's an MTR deal and they don't have any interest in going over it. So he's certified more there. But I'll kind of put it all in writing and put it in your file, and then we can do some kind of mobile also.
Your Honor, yes, do you have a copy of the charge?
Ms. Abrams gave me the one from yesterday.
Yes.
Good.
Yes, that's good.
Thank you, Judge. Get it, you know what I mean? But like I said,
Deputy Laura, are they here yet?
I'll put it all in the email. I know it's a lot.
No, we're still missing, they have like 2 minutes.
Okay.
No, she'll be.
All right, everyone, we're going to go on the record briefly. All right, everyone, please have a seat.
I'm closing in about 10 minutes.
Court is calling 2023 CR 4371B, State versus Marco Antonio Moreno-Vasquez. We have the interpreter here. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
And you can lower your hand if you'll state your name for the record.
Mariana Rios.
All right. And for the state,
Megan Galvin, Lauren Espinosa for state.
for the defense,
I'm sorry, Judge.
for the defense,
We're ready.
no, your name for the record.
David A. Garcia, attorney for Marco Moreno-Vasquez.
And are you Mr. Vasquez?
Yes.
All right. And state and defense, have you both had an opportunity to review the jury charge?
Yes, Your Honor. No objections.
No objection, Judge.
All right. So each of you have agreed to 30 minutes. Does anyone need a time announcement?
I do.
I need a 2 minutes, Judge.
I get 5 minutes, Judge.
Okay.
And if you could let Lauren know when she picked 8.
All right. Thank you. All right. We can go off the record and you all can continue to confer. We're just waiting for the jurors.
The cover, second, row on this side. Thank you.
Very like some.
I'm sorry.
Wherever you want.
Okay, great. Thank you. No, they're not here. Okay, no problem.
We ran into that earlier the other day.
Yeah,
This
that's great.
microphone,
Thank
when I
you.
was talking.
Okay. I'm gonna put the microphone just on the table.
Right, but that just comes with you. This one.
Technical advantage that.
Everybody-
the door-
Korean.
Okay.
It's a, well, that's when I'm looking at it, so. Okay.
David, can you approach?
If the technicality is.
What can I do that on? Ooh, do you know, or his name?
So when you get this, now you get done.
Oh, no, we're at one.
Or sneak one in. He's out there. I already finished the paperwork.
Judge, is
The
it okay
data
to
sheet,
put
so-
these here?
Yes.
Thank you, Judge.
Oh, I found him.
Okay, thank you.
Or do you want to just?
Okay, Judge,
Yes.
we got a plea, the inmate, he's in custody, we did the paperwork next door, he's actually just throwing out the data sheet, can we
Thanks.
do one real quick? I was told to ask you and not sign, I,
No. The only thing is, this jury, they always showed up on time. So it's like 9:24.
There's only 4 of them out there. There's only 4 of them out there. So that's how you- Oh, okay.
So she's gonna check, because they're always on time. Oh, they are very on time. Mm-hmm.
I'm gonna put it down just in case.
Yeah, no, I mean, you can still sign in.
Matthew Caballero. How do I spell it? Caballero? Spanish for cowboy. You just use the Y sound. Caballero. Oh, you gotta roll it a little bit. Never mind.
Judge, how to say that after?
Caballero,
That's
but I don't roll R's.
I'm not very good at rolling R's. It's not.
Judge, what is it?
Okay. Well, counsel, I will tell you
You're looking
this,
for Derek?
whether or not
Over here.
an inmate is brought out for your plea, 100% depends upon the deputies, because I don't want to put them
Thanks.
at having to do extra things.
I'll get him. Robert.
No, he says he has a plea, they've done the paperwork. Has he been sworn in?
Not yet. Oh, yeah, he already did that. Never mind.
No,
Thank
never
you.
mind.
Okay,
Okay,
I'm trying to push all that.
that's okay.
Okay.
No. Influences of Congo.
What was? I didn't see there was an offer on this.
Yes, case number. All I was seeing. Let me get that for you.
Ag robbery. Continue to do Capricorn. It is a very. I don't know what those words will be. This is kind of students and work. No, I digress. Yeah, I thought it was in the shade.
Student judge.
Yes.
I have a inmate, but the state African Fur went and asked for a short reset.
Who is your father?
Robert Efaus,
Robert who?
Efaus, Evehouse.
He's on page 7-3 now.
Continue to do or cap 20.
I mean, I'll Charles on him.
He's back from Ireland, right?
Yeah.
Oh, boy.
For themselves, John. No, his family is like.
Yes.
Rick and I have conferred, Judge, we went at short recess. He wants us to figure out what we can do other than sentence him or probation or something.
How much time are you all asking for?
My answer, I know it's not.
About 2 weeks, Judge.
All right, Norma, I need a reset date on Robert Peavehouse, 2 weeks. All right, and that'll be for disposition.
Yes, Judge. Thank you, Judge.
You're welcome.
August 4th, okay.
Mhm. Okay, just one second. And what page is that on? Sorry, who is it? Isaiah? Yeah,
I can go.
okay. Okay.
They're about to break.
No, I have written.
This needs to be the one. I'll tell it. Because their case is already deceased. The family violence is still open for them to make that.
All right, yes, yes,
Great.
Thank you, Judge.
welcome.
Uh-huh.
He needs to-
Thank you, Judge.
All right, Isaiah Gonzalez, and where is he?
He's in custody, Your Honor.
Ah, yes.
Good morning. Mr. Gonzalez is here on a family violence case, but also has two new CTD indictments. I also represent him on a pending MTR out of Colorado County, in which he has the warrant until he's released from Bexar County.
Okay.
And so I'm asking for a quick 2-week reset so I can try to get a global plea worked out and so that I may review the discovery. I just filed my notice of appearance.
All right, Norma, recall Isaiah Gonzalez for August 4th,
Thank you, Your Honor.
and that'll be for a disposition.
Thank you, Judge. May I be excused?
Yes. All right, let's line them up.
I still put my name down? That's me, my first. Okay,
I'm telling you, this jury has been pumped like nobody's business.
You got this, guys. Look. Look. It's.
And everyone, please make sure your cell phones are on silent or off. There's nothing worse than giving a closing argument and having someone's cell phone go off. And everyone needs to make sure that they have a seat. And to the deputy at the back or investigator, please don't let people come in and out slamming doors because that throws everybody off as well. All right, Cindy, are you ready? To the interpreter, you're ready?
Yes, Your Honor.
And everyone else is ready?
Ready, Judge.
All right, let's bring them out.
All rise for the jury.
All right, everyone, please be seated. So, ladies and gentlemen, this is my docket. So they're not here for this case. Everybody in the audience is here for something else completely different. So I'm going to read to you the jury charge. You don't have to memorize it. You'll be given the original when you begin your deliberations. Charge of the court. My mouse isn't working. There we are. Members of the jury, the defendant, Marco-Vasquez, stands charged in count 1 of the indictment with the offense of murder, alleged to have been committed on or about the 16th day of February 2023 in Bexar County, Texas. The defendant, Marco-Vasquez, stands charged in count 2 of the indictment with the offense of deadly conduct alleged to have been committed on or about the 16th day of February 2023 in Bexar County, Texas. To these charges, the defendant has pleaded not guilty. 1, our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual, or if he intends to cause serious bodily injury and commits an act clearly dangerous to human life that causes the death of an individual. 2, our law provides that a person commits the felony offense of deadly conduct if he knowingly discharges a firearm at or in the direction of a habitation and is reckless as to whether the habitation is occupied. 3, individual is defined as a human being who was born and is alive. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means a bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Deadly weapon means a firearm or anything manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Habitation means a structure that is adapted for the overnight accommodation of a person and includes such separately secured or occupied portion of the structure and each structure appurtenant to or connected with the structure. 4, a person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct when he is aware of the nature of his conduct. A person acts recklessly or is reckless with respect to the circumstances surrounding his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that circumstances exist. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 5, our law provides a person is criminally responsible as a party to an offense if the offense is committed by his own conduct or by the conduct of another for which he is criminally responsible, or by both. Each party to an offense may be charged with the commission of the offense. Mere presence alone will not make a person a party to an offense. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. 6, you are instructed that an accomplice witness, as the term is hereinafter used, means any person connected with the crime, charged as a party thereto, and includes all persons who are connected with the crime as such parties by unlawful act or omission on their part, transpiring either before or during the time of the commission of the offense, and whether or not they were present and participated in the commission of the crime. You are instructed that a conviction cannot be had upon the testimony of an accomplice witness unless the jury first believes that the accomplice witness's testimony is true and that it shows the defendant is guilty of the offense charged against him. And even then, you cannot convict unless the accomplice witness testimony is corroborated by other evidence tending to connect the defendant with the offense charged, and the corroboration is not sufficient if it merely shows the commission of the offense, but it must tend to connect the defendant with its commission. The witness, Adis Hernandez Rivas, is an accomplice if an offense was committed, and you cannot convict the defendant upon his testimony unless you first believe that the portion of his testimony that ascribes guilt to the defendant is true and shows that the defendant is guilty as charged. And then you cannot convict the defendant upon said testimony unless you further believe that there is other evidence in the case outside of the evidence of the said accomplice witness tending to connect the defendant with the offense committed. If you find that an offense was committed and the corroboration is not sufficient if it merely shows the commission of the offense, but it must tend to connect the defendant with its commission, And then from all of the evidence, you must believe beyond a reasonable doubt that the defendant is guilty of the offense charged against him. 7, count 1. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 16th day of February 2023 in Bexar County, Texas, the defendant, Marco-Vasquez, either acting alone or together as a party with Adis Hernandez-Rivas, did intentionally or knowingly cause the death of an individual, namely Dunel Valadares Fernandez, by shooting Dunel Valadares Fernandez with a deadly weapon, namely a firearm, or the defendant Marco-Vasquez either acting alone or together as a party with Adis Hernandez-Rivas with intent to cause serious bodily injury to an individual, namely Dunel Valadares Fernandez, did commit an act clearly dangerous to human life that caused the death of Dunel Valadares Fernandez by shooting Dunel Valadares Fernandez with a deadly weapon, namely a firearm, then you will find the defendant, Marco-Vasquez, guilty of the offense of murder as charged in count 1 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Marco-Vasquez, not guilty of count 1. 8, count 2. Now, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 16th day of February 2023 in Bexar County, Texas, the defendant, Marco-Vasquez, either acting alone or together as a party with Adis Hernandez-Rivas, did knowingly discharge a firearm at or in the direction of a habitation, and Marco-Vasquez either acting alone or together as a party with Adis Hernandez-Rivas was reckless as to whether the habitation was occupied, in that Marco-Vasquez either acting alone or together as a party with Adis Hernandez-Rivas failed to make adequate inspection or inquiry regarding the presence of others therein, then you will find the defendant, Marco-Vasquez, guilty of the offense of deadly conduct as charged in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Marco-Vasquez, not guilty of count 2. To ensure that the jury, the court, and the parties are all receiving the same testimony, whenever a party or a witness does not speak English, the services of an interpreter are employed. You are instructed that you, as the jury, are to base your deliberations on the questions as they came from the attorneys in the English language and the responses from the witness as they came from the interpreter in the English language. You are instructed that under our law, no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. Therefore, if you believe or have a reasonable doubt that evidence was obtained in violation of any provisions of the Constitution or laws of the state of Texas or of the Constitution or laws of the United States of America in such event, the jury shall disregard any such evidence so obtained. You are instructed that a statement made by a defendant is to be wholly disregarded and not to be considered for any purpose whatsoever by the jury if the following 3 circumstances exist. 1, the statement is given as a result of custodial interrogation. A person is considered in custody only if, based upon the objective circumstances, a reasonable person would believe he was restrained to the degree associated with a formal arrest. B, custodial interrogation is defined as questioning initiated by someone in the role of a law enforcement officer after a person has been taken into custody or otherwise deprived of his freedom of action in any significant way. C, custodial interrogation exists when a reasonable person would have believed he was not free to terminate the interview and leave. D, in determining whether a person is free to leave, the following factors are considered. 1, whether probable cause to detain the person existed at the time of questioning. Probable cause exists when facts and circumstances within an officer's knowledge and about which he has reasonably trustworthy information are sufficient to warrant a person a reasonable caution to believe that an offense was or is being committed. 2, the subjective intent of the officer or functional equivalent of a law enforcement officer during the questioning. 3, the focus of the investigation. And 4, the subjective belief of the individual being questioned. 2, and prior to making such oral statement, the accused was not given the following warnings by the person to whom the statement is made. A, that he has a right to remain silent and not make any statement. B, that anything said by the defendant will be used against him at trial. C, that the statement will be used against him in court. D, that he has a right to terminate the question at any time during the interview or questioning. And E, that he is entitled to the services of an attorney, his own, or if he is unable to employ one, a court-appointed attorney to advise him prior to and during any questioning or interrogation. 3, and the defendant did not knowingly, intelligently, and voluntarily waive such rights if they were given. A defendant's statement may be considered voluntary when there is overreaching in the form of official.
Judge,
I'm sorry.
you read it as voluntary.
Oh, I'm sorry, involuntary. Thank you. A defendant's statement may be considered involuntary when there is overreaching in the form of official coercive conduct by the person during the questioning of such a nature that any statement obtained thereby was likely to have been the product of an essentially free and unconstrained choice by its maker.
Judge, you said likely, it's unlikely.
Wait, did I say that? Oh, I'm so sorry, guys. The letters are running together up here. All right, let me repeat number 3 to you all, but don't worry, you'll have a copy of the handwritten charge, and the handwritten charge is what you go by for the law. Does everyone understand?
Yes.
Okay. 3, and the defendant did not knowingly, intelligently, and voluntarily waive such rights if they were given. A defendant's statement may be considered involuntary when there is overreaching in the form of official coercive conduct by the person during the questioning of such a nature that any statement obtained thereby was unlikely to have been the product of an essentially free and unconstrained choice by its maker. You are instructed that unless you believe from the evidence beyond a reasonable doubt that any statement introduced into evidence was freely and voluntarily made by the defendant without compulsion or persuasion, or if you have a reasonable doubt thereof, you shall not consider such statement for any purpose nor any evidence obtained as a result thereof. Our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You are not to use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers or police reports made by officers and tendered to the prosecution, to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive the law from the court which is hearing given to you and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you, in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communication relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. State and defense, are you prepared to proceed?
Yes, sir. Yes, sir.
Yes, Your Honor.
All right, state, you may proceed.
Ladies and gentlemen, as judge just read to you, this is the charge of the court. This contains all of the law that you will be able to take back with you to conduct your deliberations, and you are bound to the law herein. We're going to go through the elements of the charge and break down everything you have to deliberate. So we're going to start with the law. Here, Mr. Marco-Vasquez is charged with 2 counts. Count 1, murder, and count 2, deadly conduct. Now, murder is separated into 2 paragraphs, meaning there are 2 ways by which he's charged with murder. Paragraph A's elements are that on or about a date, February 16th, 2023, in Bexar County, Texas, the defendant, Marco Moreno-Vasquez, did intentionally or knowingly cause the death of Daniel Valadares Fernandez by shooting Daniel Valadares Fernandez with a deadly weapon, namely a firearm. Paragraph B's elements are on or about February 16th, 2023, in Bexar County, Texas, the defendant, Marco Moreno-Vasquez, did intend to cause serious bodily injury and commit an act clearly dangerous to human life that caused the death of the complainant, Daniel Valadares Fernandez, by shooting the complainant with a deadly weapon, namely a firearm. Now, it's important to remember, as we discussed in voir dire and as the charge states, that a deadly weapon, being the firearm, a firearm is per se a deadly weapon, okay? And it says that in the charge. Now, count 2 is deadly conduct with a firearm. And the elements of this count 2, are that on or about February 16th, 2023, in Bexar County, Texas, the defendant, Marco Moreno-Vasquez, knowingly discharged a firearm at or in the direction of a habitation and was reckless as to whether the habitation was occupied, in that he failed to make adequate inspection and inquiry regarding the presence of individuals therein, okay? Now, we're going to go over the mental states. Remember, you're not required to be mind readers, okay? You may make inferences based on words, actions, and the surrounding circumstances. In the charge, it discusses the 3 mental states, the first one being intentionally. Someone acts intentionally when there is a conscious objective or desire to engage in the conduct or cause the result. Okay, as Megan told you in jury selection, you can ask yourself, did you mean to do that? That's when someone acts with intent. Now, something is done knowingly when the individual is aware of the nature of his conduct or the circumstances that exist. Did you know what you were doing when you did that? And finally, recklessly, you act recklessly when you are aware of but consciously disregard a substantial and unjustifiable risk that the result will occur. Did you know there was a big risk that could happen when you did what you did, but you did it anyway? Now let's discuss the law of parties. So a person is criminally responsible as a party to an offense if the offense is committed by his own conduct, by the conduct of another for which he is criminally responsible for, or by both. Now, a person is criminally responsible when they're acting with intent to promote or assist the commission of an offense, that he solicits, encourages, directs, aids, or attempts to aid the other in the commission of that offense. Now, the accomplice witness rule. An accomplice witness means any person, if they participated in the offense before or during its commission, and they can be prosecuted for that same crime. Now here, you must first believe that the accomplice witness's testimony, so here, Audis Hernandez Rivas' testimony is true, and that the defendant is guilty of the crime, and then further believe there is corroborating evidence showing, intending to connect Mr. Marco Moreno-Vasquez with that offense. Now remember, ladies and gentlemen of the jury, testimony is evidence. And in this case, you saw a lot of photos, you saw videos, and you heard from numerous witnesses from that witness stand. All of that combined is evidence in this case, and you, though, are the sole juror, exclusive judges of the facts to be proven in this case, the credibility of the witnesses you heard from that stand, and the weight that you give their testimony. You are instructed in the charge that you are not to let bias, prejudice, or sympathy play any role within your deliberations. And you were also instructed that your sole duty right now is to determine guilt or not guilty under the indictment in this cause, and that you are to restrict your deliberations to solely that issue and nothing else. We will reserve the remainder of our time.
Defense?
Thank you, Judge. Good morning. So we're finally at the end of our trial. You know, we started Monday or Tuesday, and you heard a lot in voir dire. And one of the important things, or two of the important things, was you are the triers of the facts. Prosecutor told you that it's in your charge. What does that mean? It means you get to decide of the testimony that the DA brought you, whether you believe it or not, okay? And you can disregard part of it or all of it if you didn't believe it, okay? You did not believe it, you can disregard it completely. Why is that important? Because you heard testimony from officers, from civilians, from experts in this case. And you have to look at this case as it's a murder charge, and if you want to just find somebody guilty, find Marco guilty. Okay, but that's not how our system works, right? We're the greatest country in the nation, and one of the reasons we are is because we have the greatest criminal system in the world. Marco sits there completely innocent at this point. The only way he will be found guilty is if, when you go back and deliberate, you believe the evidence or part of the evidence and say, you know what? Beyond a reasonable doubt, as to each and every element, I believe that Marco did this. Okay. But by the same token, under your oath, you've got to look at everything. You've got to discern whether you believe it beyond a reasonable doubt. So let's think about the testimony. I was a little hard on the officers, okay? I don't suffer fools lightly, and I'm not insulting the officers. They have a tough job, all of them. When we're in trouble, if I'm in trouble, if I can't defend myself at that moment, I want the police to help me, just like anyone else. But by the same token, there are rules under our Constitution that must be followed, to you, to me, to Marco. And the question is, did they follow those rules? They were a little haphazard, nonchalant about their testimony and what they did. Even the detective that they finally brought at the end, Detective Waits, who's supposed to be in charge of the whole thing, did he say he was in charge of the whole thing? No. It's a team effort, and we kind of put things together. This is the 7th largest city in our nation. Is that how you want investigations to work? Okay. So if I was a little too rough on them, I apologize, but I have a job to do. And that's to protect the rights under the Constitution to Marco here. And I take that extremely serious. And so let's talk about what they brought you. They brought all these people. Think about, of all the people that they brought, who were the ones that didn't have an agenda? Who were the ones that were either just strictly science or had nothing to gain? In this case, they brought you the medical examiner, right? She told you it's all about the science. And does she help us in any way other than tell us that Danielle was killed by a gunshot wound? No. Other than that, that's kind of it. But she also didn't say that there were beating marks on Danielle. There were bruises to his head, to his torso, to his arms, defensive wounds. You didn't hear any of that. And I got that out of Detective Waits. Okay, I didn't have to ask the MA because if there was evidence, they would have brought that out. Remember, it's their job to bring out the evidence, not mine. I'm just pointing out to you what's blatant and missing. That's going to be important when I talk about Adis's testimony. Who else did we hear from that had no gain in this? The ballistics guy, right? He just does the science of testing the guns, testing the spent shell casings. And here, what he testified was that one of the guns, this one, that the spent shell casings found at the house, okay, where Danielle was killed, there were 4 spent shell casings that were sent to him that matched this gun. Reasonable conclusion, this gun was used to kill Danielle, okay? Unless there's not a bullet that matched, and there was no testimony regarding that. But this gun was clearly used at Danielle's house. Who had this gun when he was shot? We don't know. They're going to argue that it was Marco. Adis said that it was Marco. Okay, we'll talk about Adis in a minute. Who else was not biased in this? I submit to you that the daughter, Roxanne, she was 13 or 14 at the time, because this is an old case. What did she tell you? She told you what she saw happen, that her entire family was put in a Suburban, driven by her mother, with Marco sitting in the passenger seat, Adis sitting in the back seat with the kids, behind the driver. And they drove and they went to Dairy Queen and ate. She was super happy at that moment. Okay. It's kind of a surreal story when you think about this, but life and truth are stranger than fiction. You can't make this stuff up. What does she say next? That they drive over to Danielle's house, whom she doesn't know. She doesn't know this location. And she says her father, Marco, and Adis get out and they walk to this gate, and she's parked where she can see everything. It's still dark, but she says, I can still see. And she's parked parallel to the entrance where that gate is. The windows are up. It's quiet in there. And she sees an argument, and she sees Danielle pull out a gun that he got from the back seat, the pocket of the back seat that he was sitting in front of, behind that one, and walk out, and that his father walked out with a gun also. Now understand, I don't get to come back after the DA talks, and they're going to be like, aha, that's it right there. He had a gun and he used it, so he's guilty of murder. But what does Roxana tell us? She tells us that Adis starts shooting, and when he shoots straight at Danielle, and Danielle goes down. And then her father shoots into the ground, and then they run back. Okay. They run back. This is the witness they put on. I didn't put that on. They did. And then they drive straight back to the house in Poteet. And then they drive, she said, to Austin to go to family with Adis with them. When you look at that story, why would anyone take their family to go shoot someone? That doesn't make any sense. I submit to you, if you look at the transcript that was put into evidence, I believe it's 217, Marco's trying to tell the cops, trying to tell the detectives, and you understand there's a Spanish barrier here, and they had Officer Arias, Sergeant Detective Arias, there to translate. And I asked them, how many times did Marco bring up his family? You have the transcript and evidence. When you take it to the back, take a look at it. 6 or 7 times. And State tried to bring out, well, he was distancing himself from the event. No, He's trying to tell him he's worried about his family. Why would he be worried about his family? And the kicker there is where in the transcription, he says, look, I'm going to tell you the truth. But is this information going to get back to Adis? Why would he do that? Why would he be afraid of Adis finding out that he's talking? And Arias says, yeah, I told him he's not going to know about it, which we all know is a lie. We all know that eventually the bad guy's going to hear about it. And he was in fear for his life, for his wife, his kids, and for himself. And so did he not come out and say, listen, the guy threatened me with a gun, he threatened to kill my family? He didn't, not in those words. But by the same token, you heard from you heard from Lorraine earlier. Okay, what did she say? That she, actually it was not Lorraine, it was the other woman at the scene. And she said she didn't call the police because she speaks Spanish. She called Lorraine to call the police. We all know that the dispatchers speak Spanish. There are signs all over our city in Spanish, but yet there is a barrier. And so that barrier precluded Marco from telling the police, even though he tried, that he was in fear for his life and he was forced. And I submit to you what happened was Adis threatened him and said, you guys are going to come with me. And what more threatening is there than to make him bring his family with him to make sure he won't talk? Also, you heard from Roxanne that the family went up out of town to Austin, okay, with Adis. If you're leaving town to get away because you're scared of something bad that happened, why would you take the bad guy with you? Adis. Because he's staying on top of them to make sure that Marco can't say a peep. Okay? It wasn't until Marco got brought in, arrested, you heard the officers from Atascosa who worked with Bexar County Sheriffs, arrested, handcuffed, and taken down to the patrol station to be interrogated. Okay? When he finally starts to say, and at the end he says, Adis is the one that shot him, which is consistent with Roxanne. Now let's talk about Adis's testimony. They brought him, who's a co-conspirator, an accomplice, to testify against Marco. But what's the problem with that? I don't think Adis knows the difference between a truth and a lie. How many times did he lie up there? Numerous. I could have brought Sergeant Arias back and gone through each and every lie, but there was no need. Why? Because I brought Lorenzo Calderon Gonzalez, another person with no skin in the game. He wasn't getting any benefit from me. I'm a defense attorney. I have no control over what the DAs do. He was just there to tell you the truth. And what did he tell you? Once again, there was that Spanish language barrier, but the meat of it was that Adis confessed to him that he committed this murder. Knowing that Adis committed this murder changes everything, because his testimony is basically, I did nothing, Marco did everything. Marco did it. Marco forced me. If you look at what Adis said, everything he said was reversed to make him look innocent, when the reality is that was the situation he put Marco in. He threatened Marco. Marco had to go. Marco didn't know why he was going. Just knew that he didn't have a choice, and they went down there. Marco didn't drive. Also, Marco's testimony contradicts what Roxanne said. Why would he have said they stopped at a gas station so Marco could get rid of the weapons? We know that's not true. One of the weapons is here in evidence. So that didn't happen. But why did he say it? To try to make Marco look more guilty. That he was trying to get rid of the weapons. What else does Roxanne say? That her mom and dad walked into the house and that they took the gun or guns. Why would they do that? Because Adis was forcing them to. Adis had access to that house. He came and went in that house. So he made sure the gun was there so that when the cops finally came, it would make it look like Marco was the bad guy. What else do we know? We know that there's no evidence of DNA, there's no evidence of fingerprints, and there's no evidence of gunshot residue. If there had been, they would have brought it, but there's not. They're probably going to jump on the fact that there were other spent shell casings found at Marco's house, and that shows that he dumped them at his house. That doesn't make any sense. What else did Adis tell you? That Marco bent over and picked up his spent shell casings from which he fired. Why would he do that? The evidence only showed the 4 spent shell casings that all came back from this gun. The spent shell casings found at the house that matched that gun weren't from a different gun. They were from this same gun. Adis had access to that house. I submit to you that taking Adis's statements, it shows you his real intent. But by the same token, as the jurors of the facts, the triers of the facts, you can discount everything he said. Okay? Completely, because it's all lies. That leaves you with Roxanne's story and the transcript by Marco. Let's talk about the transcript by Marco. You saw the Sergeant Arias testify to. You're going to have State's Exhibit 217 back there with you. Look at pages 5 and 6. Remember, this is a country ruled and governed by laws. The police have to follow that law. It's in your charge. They have to read you your Miranda warnings before you give a statement. And you have to say yes to each and every right. When you go through this on page 5 and 6, you're not going to see that Marco said yes to every right. Take it back there and look. I'm not going to waste time on that, because once you see that, his statement was not voluntary, intelligently, or knowingly given. And under the law, you can throw it out and disregard it. But what I want you to have taken from his statement was his fear, to show that he was deathly afraid for himself, but more for his children. And it's in here, if you go through it. I brought out several instances, but there are more. What else do we know? We know that Ada said he didn't kill Danielle. We know he did. You look at him, he's a stone cold killer. You saw him up there. Did he look at you once? Not once. He knew he was lying. He even refused to admit that he was lying until I broke him down. The state's going to come back and say, you know what? Mr. Garcia made some good points. Okay. Maybe he wasn't the shooter, but we're going after it for acting in concert. That he was part of the team with Adis to kill Danielle. Okay. In order for that to happen, they have to prove, and it's in your charge, that he aided, he abetted, he conspired with, he assisted. You take all of the testimony together and the one that you believed happened from Roxana, there was never any talk. that he was going down there to assist or to shoot Danielle. There was never any talk about why. They're gonna talk about motive, and they brought other witnesses to try to say, to try to imply, to try to infer that maybe Danielle owed him money. You have the witness who testified about being in Houston with a stack of money. You can't infer any of that. They didn't bring you direct evidence. You cannot let bias, sympathy, any of that come into play just because there's a dead body here. I feel sorry for Danielle. They have the killer who's Adis. He'll be sentenced later. But as far as Marco's concerned, he was a pawn. He was a patsy that Adis tried to use and used effectively. Now, Marco didn't testify because you heard some of it. And they're going to argue, well, why didn't he say he was being threatened? Why didn't he say any of that? He could have done that because he was scared, ladies and gentlemen. Imagine somebody putting a gun to you and threatening to kill you, your wife, your children. What are you going to do? Are you going to run to the police? Some people would. Other people would be too scared because the most important thing in their lives are their children. So he kept his mouth shut. And he stammered and he said stupid stuff in that interrogation. But the reality was he was trying to get across the point that he couldn't because he was in fear for his children. There was no distancing, which they're going to claim. There wasn't. And so he could have gotten on the stand and said that. But because they failed to prove that he's guilty beyond a reasonable doubt as to each and every element, he felt, and I agree, that he didn't need to because his story was already there. So if you follow your oaths as jurors and follow the law given to you by the judge, you're going to find that you cannot believe that he was a part of this willingly, knowingly, under acting in concert. He wasn't. Remember, under the accomplice witness rule, besides Adis just being a complete liar, you can throw all that out because there's no corroborating evidence as to Marco being part of a team with Adis. They'll probably use, well, the defense counsel talked about Roxana. That corroborates it, but only as to him shooting down into the ground. You know, they have him charged with murder and deadly conduct. Shooting down into the ground is not shooting at a house. It's not shooting at Danielle. And they're going to say, well, we have proof because of the gun in the refrigerator. You know, ladies and gentlemen, if you believe that he and his wife remember, it's not his wife, it has to be him, put that gun in the fridge at his house, that would be tampering with evidence, not murder and not deadly conduct. And that charge is not before you. Now, you may have questions after the prosecutor gets up and speaks and you go back and deliberate. If you have any questions as to the testimony, and court reporters hate me for saying this, they all do, okay? You have a right to have the testimony read back, but it's very important because there's a rule and you have to follow that rule. You have to tell the court in your question what the issue is, and it has to be so narrow as to who or whom said it, so that they can go back and just read that one sliver of testimony. It can't be, I want to hear all of Danielle's testimony. I want to hear all of Roxana's testimony. It has to be very specific and limited, but you have that right. Okay? Now, as jurors, when you go back there, it's in the charge. You're going to have to pick a foreperson. So you'll do that, but then you're going to deliberate as to the evidence, as to guilt or not guilty. And on that, you have to hold on to what you believe. That's the beauty of our system. I'm not saying you to be rigid. I'm saying to be strong in your belief. Don't just go back there and if, the person next to you is like, it's obvious he's innocent or it's obvious he's guilty, don't just give in. Make them explain to you why. Because if you have a reasonable doubt as to each or any of the elements beyond a reasonable doubt, that alone is enough to find him not guilty. And I submit to you, there are a lot of reasonable doubt. There's a lot of reasonable doubt in this case.
5 minutes.
So I'm just going to push some of the language in the charge. The person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. There's no testimony, none whatsoever, that is believable that Marco shot Danielle. Adis, you can disregard him several different ways. Accomplice rule, or just the fact that he's just a horrible liar and is not to be believed. You can completely disregard his testimony. You just have Roxana putting him there, him putting him there in his statement if you don't throw it out. But there's no testimony that he fired at Danielle. The only testimony is from Roxana that he fired down. That's not the conscious objective or acting in concert to kill someone. Law provides the person is criminally responsible as a party to an offense if it's committed by his own conduct, we know it's not, or the conduct of another. So they're going to say he was acting with Adis. Okay. Here, they have to show how. That he solicited, no evidence. That he promoted, no evidence. That he assisted, no evidence. That he encouraged, nope. Directs. Adis tried to tell you that he directed it. Can't believe Adis. Aids or attempts to aid the other person to commit the offense. There's no evidence of that. None. That is believable. So they can't get you there. Accomplice witness. Like I said, there's no testimony corroborating Adis's testimony, which was pure lies. Remember, when you go back, look at pages 5 and 6 of the transcript, because you're going to find that the officers did not fulfill the Miranda rights. And under that, you've got 3, custodial interrogation. We know he was arrested and put in a room. We know he was being interrogated. And they had to read him his warnings, which they did, but they didn't let him answer. That he understood. And on some of them, he said yes. On others, he said, it's not yes. So they failed to have him state something knowingly, intelligently, and voluntarily. And thus you can throw it all out. Like I said, you can't hold it against them because he didn't testify. You're not to let bias, prejudice, or sympathy play any part. We have a dead person here. But this case is whether they proved that he committed that offense, either himself or acting in concert. They didn't meet that. Here's the most important one. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. So you have to believe it's beyond a reasonable doubt. I submit to you, the testimony they brought, other than the experts in Roxana, you cannot believe beyond a reasonable doubt. The presumption of evidence alone is sufficient to acquit the defendant. Even if he was present and you believe he was, because Roxana puts him there, that alone is not enough to find him guilty. Whether you like him, like me, dislike me, that doesn't come into play. It's the law and what they brought you and what they didn't bring you. And they didn't bring you evidence beyond a reasonable doubt that Marco-Vasquez is guilty of committing this murder either by himself or with aiding with aiders. Thank you for your time. On behalf of Mark and myself, I know you'll go back there, deliberate and do the right thing. Thank you.
All right, state.
I don't know, I don't know, I don't know. That was the response, not spoken by an innocent man, but by this defendant who sits here before you today, asking you all to find him not guilty when he knows that he acted in concert with Adis Hernandez Rivas and orchestrated the killing of Duniel Valadares Fernandez. On that day, he put greed over humanity. I told you all that in my opening statement, and I utter it again to you all today. Now, I'm going to turn to the law. Okay, we've talked about intentionally and knowingly. You all know the definition will be in the jury charge. But Mr. Garcia argues to you that there's no evidence of intentionally or knowingly. Okay, and so I told you all in jury selection that you all are allowed to infer from words, actions, circumstances, and facts. Okay, so let's look at what that looks like in this case. Okay, what was the defendant's desire on that day, right? It was to go to the location and collect the money that Duniel owed him, not Adis. And you all heard that from Masalud Zubieta, and you also heard that from Roxana. How did the defendant act knowingly, right? He goes there armed with a firearm, and he knows that Adis is armed with a firearm, because if you believe the testimony of Roxana, which Mr. Garcia has asked you to do, Roxana testified that her dad is the one that provided Adis with that firearm. Now let's talk about the testimony that you all heard in this case. You guys heard from Deputy Maxwell. He testified that he was dispatched to that 7718 Winsford Drive, and he was first on scene. He was dispatched there for a shooting. Okay, he told you all that he observed two females that told him, hey, go to the back. And that when he went back there, he observed Duniel face down, suffering from a gunshot wound. Okay, he started CPR, and then he participated in life-saving measures before turning to his law enforcement duties. Okay, and he told you all that he saw those 4 shell casings that were there in front of the gate, and then he contacted the follow-up unit. You guys heard from Deputy Perez, and he testified the same. He was riding along with Maxwell. He observed 2 females and a male that led him to the back of the location. He also observed Duniel face down, suffering from a gunshot wound, assisted in the life-saving measures, then turned to the law enforcement duties. Now, he testified that he saw the 4 shell casings as well, and that he was the one that noticed that that home was equipped with DVR. Okay, and he inspected that DVR system, and he didn't observe any wires being tampered with or anything of that nature. Then you guys hear from CSI Anderson, and he testified that he was briefed by Deputy Perez. He seized those 4 shell casings, okay, which were labeled as CA 1, 2, 3, and 4, and that has been entered into evidence as State's Exhibit 65, okay? And he also testified that he observed those defects to the home, and he took the photos and the video that has been entered into evidence, okay? You heard from Dr. Ward. She identified Daniel Valadares Fernandez, and she confirmed his identity through fingerprinting. She testified that Daniel died of a gunshot wound to his torso and that the entry was in his upper back, okay, and that exit was on the left side of his chest, and that she determined the manner was a homicide. Now let's talk about the testimony of Marcel Lucieta. Okay, this is another person that had absolutely nothing to gain from her testimony. And what did she tell you? That she was the owner of 7718 Winsford Drive. She knew Daniel and his nickname was Cubano, that he was there living at the location, and that she was not present during the shooting. But when she arrived home, she observed Daniel in the fetal position. She contacted Lorraine to call 911. She provided her statement to deputies and then provided that video footage to the Bexar County Sheriff's Office. But what is most important about her testimony? That when she reviewed that video surveillance herself, she recognized this defendant. She didn't recognize Adis Hernandez Rivas. She recognized Marco-Vasquez. And she told you all that in the weeks leading up to the shooting, Marco-Vasquez, not Adis Hernandez Rivas, this defendant went to her home and asked for Cubano. And why is that important? Because if you look at the defendant's statement in State Exhibit 217, he tells you he has absolutely no idea who Daniel is. Okay, and Mr. Garcia cannot have it both ways. Okay, he cannot ask you to listen to some parts of the statement and disregard other parts, because if you look at the charge and the statement that was taken by the defendant, okay, it was a custodial interrogation. Nobody is disputing that. But when you do look at State Exhibit 217, you are going to see that the officers read the defendant his rights in accordance with the law. And he asked the defendant, "Can we talk?" The defendant states yes. Mr. Garcia submits to you all that the defendant's responses of don't count as yes. But I urge you all to look at the further parts of the interview when he uses the word multiple times to indicate yes. And so if you look in the charge, what the charge says is, if you believe that that statement was taken in violation of the laws, then you shall not consider any part of that statement. And so Mr. Garcia cannot have it both ways, okay? But I submit to you that the statement was taken in accordance with the law. But let's get back to Ms. Zubieta's testimony, okay? She also testified that she knew the defendant, Marco Vasquez, to own a white truck. Why is that important? Mr. Garcia started making a big deal. Are you sure it was white? Are you sure it was white? And then when we look at Fernando Luna, Deputy Fernando Luna's body-worn camera, what do we see? In addition to the suspect vehicle that was used in the murder, we see that white Dodge Ram. She also testified that officers with the Bexar County Sheriff's Office made contact with her again days after the murder, and that was confirmed by Detective Waits that they went back out there on February 22nd of 2023. That is the day that they collected that projectile that was found in her son's bedroom closet. And she testified that her home did not have bullet hole defects prior to Danielle's murder. Then we hear from Cynthia Cortez, okay, and she lives at 6928 Oldham Drive. And that's about a minute up from the 7718 Winsford location. And it's closer to the Montgomery side, to the exit of Camelot 2. And her home was equipped with cameras, and she provided that footage to the sheriff's office. And then we have the pole cam, that screenshot. That pole cam was situated right there on the corner of Winsford and Montgomery Drive. And that was the only entrance and exit to Camelot 2. And that plate led to the next witness, Juan Carlos Ortega, okay, who was a registered owner of the Chevy. However, you heard from him, and he testified to you that he sold that motor vehicle to Marco Antonio Moreno Vasquez. that defendant, not Adis Hernandez Rivas. And then he also provided the address of 74 Kimberly Lane that lines up to this defendant. And then that phone number 210-574-2898. Then here is when the Atascosa Sheriff's Office gets involved. All right, they go out to that location. And what do they find? When they're conducting surveillance at 74 Kimberly Lane, they observe their suspect vehicle with a board covering the license plate. All of these facts and circumstances that Mr. Garcia tells you, that would be tampering with evidence. And that's not a charge before you. And while it's not a charge that you can find him guilty of here today, all of those facts and circumstances go to whether he's guilty or not. And it goes to whether he was a party and whether he aided Adis Hernandez Rivas. And I submit to you that the answer to that is yes. Then you heard from Deputy J.D. Ruiz, okay, on February 23rd of 2023, he conducts that traffic stop on Ogden Road. And he pulled that Nissan Pathfinder over and identified the persons and the motor vehicle. And so who was the driver? Eunice Lugo Davila, okay, and that is who it kind of lines up with what Roxana said about her godmother and that she knew her by the last name of Lugo. Then the front passenger was Adis Hernandez Rivas, and in the back seat was the defendant and Ramona Martinez, his wife. Then you heard from Deputy Luna. So he's the one, he also conducts surveillance. He observes that motor vehicle with the board covering up the license plate. He observed the Nissan Pathfinder arrive there at 74 Kimberly Lane, with Eunice Lugo being the driver. And he observes the defendant, Ramona and Adis, enter that Nissan Pathfinder. Now he makes a scene of the traffic stop, and then he receives that search warrant and executes the search warrant. And what does he find in the defendant's fridge? Not Adis Hernandez Rivas' fridge, the defendant's. State's Exhibit 211A. Okay, and Roxana told you all that her father provided this firearm to her mother and that it was hidden in that fridge by the defendant and his wife, not by Adis. And then the other thing is that while the sheriff's office was conducting the search of 74 Kimberly Lane, there were multiple shell casings in the backyard, and those were collected and entered into evidence as State's Exhibit 215, okay? Then you hear from CSI Christina Ibarra. She makes a scene. She's the one who seized all of this physical evidence, State's Exhibits 211, 212, and 215, right? And then you heard from David Pendleton, right? And he testified to you all that he received State's Exhibit 65, which were the shell casings that were collected by CSI Anderson, and that these shell casings were fired by this firearm. And then what else does he tell you? That he received State's Exhibits 215 in his lab. And when he did the comparison, it came back to State's Exhibits 211A. He also informed you all that revolvers do not eject shell casings. And that is important because State's Exhibit 212, when you look at the photos, State's Exhibit 212A is this revolver that was found in the defendant's master bedroom. Then you heard from Adis Hernandez Rivas, and he had many things to say, right? He said that he had only been in the US for about a month. This is corroborated by 3 hours into the interview when the defendant finally starts to give a self-serving version of what happened. He admits to that. He says, I've only known him for about a month. Adis told you that the defendant is the one that solicited him when Adis was downtown looking for work, and that the defendant provided him with work. And what was that work? Tending to the horses on the properties, which there are multiple pictures of that were entered into evidence, and also uprooting cactuses and things of that nature. But Mr. Garcia then asked Adis, well, did you receive payment for this? And what was Adis's answer? No, because I was being provided with food and shelter. And so if you look at the dynamic that Adis had with the defendant, okay, the defendant is in a greater, more powerful position over Adis. Adis told you that they left from 74 Kimberly Lane to go to the murder location. He testified that Adis and the defendant both possessed firearms at this time, and that they both exited the motor vehicle. Adis stated that he heard the defendant arguing with Danielle about this monetary debt, and he observed the defendant shoot Danielle, and Adis admitted to you all that he did discharge his firearm as well. Now, you've already been explained the accomplice witness rule. I'm just gonna breeze over it, but if you believe Adis's testimony and you believe that what he is saying shows that the defendant is guilty, then you can believe it as long as there's other evidence to support what he's saying. And I submit to you all that the testimony of Masalud Zubieta, that video at 7718 Winsford Drive, and the testimony of Roxana Martinez all corroborate what Adis had to say. And now let's turn to Roxana's testimony. What did she say? Adis lived on the camper at 74 Kimberly Lane, that they all left from 74 Kimberly Lane to the murder location. And Mr. Garcia, what the testimony was, okay, was that they went to Dairy Queen, and then Roxana said that they went back to 74 Kimberly Lane. And when they were back at 74 Kimberly Lane, the only individuals that exited that SUV were the defendant and Adis. And when she observed her father coming back out from that main living structure on 74 Kimberly Lane, she observed her father with a firearm nestled in his waistband in his back. That's what she told you all. She testified that Adis obtained his firearm while they were in the car, okay? And she testified, this is a big part that Mr. Garcia left out, that her father discharged the firearm at and in the direction of Danielle. That's what she testified to, and that was a question that was elicited by Mr. Garcia. And then she testified, I already went over about the firearm and her father taking it from Adis and giving it to her mother to put it in the fridge and hide it. And then she testified that they fled to Austin. All of that lines up with what Adis said. Now let's talk about the interview. I submit to you all that the defendant was read his rights in accordance with the law. But what does the defendant then say? Oh, I don't know who Adis is. Adis never stayed at Kimberly Lane. I don't know anything about that Chevy SUV. That's not me at the murder location and the screenshots that you're showing me, detective, even though you can see my daughter's name, Chanel, tattooed down my arm. Not me. He said that he doesn't know Danielle. He had nothing to do with Danielle's death. He had no idea that he died. He stated that he never moved forward into the gate. These are all statements that are eviscerated when you look at the video that was seized from 7718 Winsford Drive. He stated that he doesn't own firearms, yet there's shell casings riddled in his entire backyard. He further stated that the shots that are reported in his neighborhood, oh, those are from a neighbor up the street. And he moved a while ago, even though they're shell casings all in his backyard. And then he stated that they left from and returned to Adis's house, when we know that that's a lie, because Adis and Roxana told you that they both went back to 74 Kimberly Lane. He also told the detective that he had no idea where their murder weapon was while it was sitting in his fridge. Detective Arias gave this defendant every opportunity to tell his truth. And he lied for 3 hours until he's confronted with physical evidence, actually. And then he concocts this story where he has no criminal responsibility. Okay, and then he's confronted with witness statements. Once he knows that his wife Ramona has said that that's him in that screenshot, oh, okay, that is me. Then he concocts a version that is not supported by the evidence, where he has no criminal responsibility. That is not the truth. They're asking you to believe that the defendant was so scared. I submit to you there's no physical evidence to support that. But look at the defendant's body language on the video from 7718 Winsford Drive. Does that appear to be somebody that's in fear to you all? When he's kicking the gate open, when he's shaking his hand like that at Danielle and sitting there with his arms crossed, that's not an individual that is in fear. That is an individual who put greed before humanity. That's an individual that went to that location to collect on his debt, and he knowingly engaged in behavior that caused the death of Danielle.
5 minutes.
Thank you. The story that they're telling you all is not supported by any of the evidence that has been submitted to you all. And then you heard from Detective Waits. He was the lead investigator, and after reviewing all of the evidence, his conclusion was that the defendant acted in concert with Adis Hernandez Rivas and committed the offense of murder. Then you hear from this defense witness, Lorenzo Calderon. Okay, he's been previously convicted of family violence assault. He's currently in the Bexar County Jail for an aggravated assault with a deadly weapon. And he's currently housed with the defendant. Okay, and he comes in here and he tells y'all, Adis told me that he's guilty of murder. Adis told you all that. Adis took a plea saying as such. He has taken responsibility for his role in Danielle's death. Adis is not on trial because he has taken responsibility by entering his plea. Now, Lauren already touched on the witnesses and that you determine, but each of you have a duty to deliberate. Only you all can make this decision. And your verdict matters, ladies and gentlemen. It matters for the safety of our community. And it decides when this defendant gets to be out on the street again, when he gets to possess firearms again. And you all took your oath, but I want to turn to the law of parties. We talked about this in jury selection, and I talked to you about it in opening. I said, we are not going to be able to prove beyond a reasonable doubt that the defendant was the shooter. What I did tell you all is that we were going to prove that the defendant was criminally responsible under the law of parties. And what is the law of parties? That a person is criminally responsible for his own conduct, the conduct of another for which he is criminally responsible, or both. And we have met our burden. We have proved that to you all beyond a reasonable doubt, that by his own conduct, by him showing up there with the firearm, by him discharging the firearm at and in the direction of Danielle, that he is guilty under the law of parties. And you can examine the events before, during, and after. And that goes to the hiding of the vehicle, the covering up of the license plate with the board, the hiding the firearm, all of that goes to this. And the soliciting, encouraging, directing, aiding, or attempting to aid. We talked about this in jury selection. There were multiple examples that even telling someone or cheering them on while they're committing the offense, that counts under the law of parties as soliciting, encouraging. And you heard the testimony of Roxana Martinez. She made it clear to you all that her father fired at or in the direction of Danielle to scare him. Recall her testimony.
because that is what she told you all. And just like Mr. Garcia said, she has no reason to get up there and lie. She told you all. I believe that we have proved our case beyond a reasonable doubt, and we ask you to find the defendant guilty of the offense of murder and deadly conduct as charged in the indictment.
All right, ladies and gentlemen.
Salvador. Never you. But not before.
Kamar Simpson.
Can I be excused, Judge?
Yes.
I'll let them know that we're on standby.
All right, thank you.
Thank you, Judge.
And how's it going? All right, and state, if you can see on Zamaripa, he's supposed to be pleading in a misdemeanor court.
Oh, yes.
Yes,
Yeah. I just need to write.
it's Brent Delapaz client.
I don't think the defendant is here, Judge. I don't know where Brent is.
All right, he's supposed to be in misdemeanor court entering a plea.
Oh.
Damaripa?
Yeah.
Have you spoken with your attorney?
I texted him earlier, he just told me to thank you.
All right, have you been to misdemeanor court yet? All right, just have a seat and wait for him.
You wanna step out and get water?
Eric Williams. Eric Donnell Williams. Jacob McCumber. Kamar Simpson.
Never you ever. Okay. We'll put it, I got a couple in the queue right now.
Yes. Ma'am, let me charge these.
You're
sorry.
good at you.
Thank
You were the queue. He was building.
Eric Donnell Williams. Jacob Mike McCumber.
You did?
Did he answer? Jacob Mike McCumber.
Please, so you ask me for reserve those versus it's still part of the underlying fact of it.
All right. Matthew Caballero. Is he on bond? All right, are you ready? Cindy, let me know whenever, just 1 second. Cindy, let me know when you're ready.
So if you're saying the jurisdiction of the court has been. Driving me, but anyways, okay, remind me your claim.
All right, who has Antonio Lazar?
I do, Yana.
All right, he is by Zoom.
Pull up the docket.
Oh, yes, I just got back, I just got to get a plea offer first.
Oh, have you have you spoken with the state?
No, I'm in line, Judge.
Ah, okay.
So they put in a good word, I can cut line, give me that VIP pass.
There are no VIP passes, I don't think.
Disneyland VIP pass.
No. Okay. Matthew Caballero. Council, good morning. Is this an application?
Yes, Judge.
Is it an for deferred?
Yes, Judge.
Is it agreed or no?
Agreed.
Probation, this is an application.
Thanks, Judge.
Court is calling 2026 CR 0008331 State versus Matthew Caballero. Can I have parties announced?
Ready for the state?
John Pettis for defense.
And are you Mr. Caballero?
Yes, sir.
Counsel, you received all discovery. Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Caballero, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Judge would be proceeding on the lesser included offense of deadly conduct.
No objection.
Any objection?
No objection, Judge.
And you're proceeding on deadly conduct as a third-degree felony?
Yes, Judge.
All right, Mr. Caballero, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand the state is proceeding on the lesser included offense of, just 1 second, an email came through. Deadly conduct as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand that the court would grant your application for deferred adjudication? If your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine.
Yes, sir.
Okay, I'm gonna need you to speak up so I can hear and the court reporter can hear.
Hey.
I know you have bass in your voice. Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was, Judge.
Mr. Caballero, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your Honor.
The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on the lesser included offense of deadly conduct. They're requesting $1,000 fine be probated, recommending deferred adjudication, and there's to be restitution, if any, in this cause number. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state?
It is a plea, Judge.
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motion?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years, 100 hours community service restitution, no contact with Christian Salazar, MRT, and cognitive thinking. Did you understand those were recommendations from the state? The court does not have to follow those recommendations.
Yes, Your Honor.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Judge, we offer you state exhibit number 1, including all of its facts.
No objection, Judge.
And state, have you spoken with the complainant?
We have, Judge, we spoke to them about the plea officer and they are in their compliance.
All right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented stipulation of testimony and stipulations. Court will accept it to evidence, states exhibits 1 and attachments, and review the same.
Sorry. Telling her this.
Well, yeah, I'm not really having a grasp with the underlying facts. I do understand that they get a search warrant. That's fine if you're gonna, you wanna do that.
Okay, so reset.
That's fine. Yeah. And then once you.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
I just ask we follow the agreement, Judge.
All right, does he have criminal history?
No.
How old are you?
18 years old.
Why are parents allowing children to have guns in bedrooms with laser pointers? What were you thinking?
Mom, I just want to point out, this was not agreed to by mom. This was something that was,
Why are you doing this?
Just, I wasn't really thinking about my future, what I want to do.
Well, I mean,
And in the moment, you know,
here's the thing, it's not about your future. You shot somebody in the face.
I know.
And that's your friend, and you all are playing video games, and you're pulling out a gun from who knows where you received it with the laser pointer and pointing it at your friend. Guns are not toys. So how far did you go in school?
11th grade. If everything went right, you know, my mom, she already talked to my counselor, and before I came to jail, I was going to alternative, and I was about to finish. Like, the counselor was able to help me out. You know,
Why were you going to alternative?
I got in trouble at school
For what?
with this THC. And so I was there for 45 days, and the counselor was able to help me out and lead me into direction to help me graduate, you know, so that way I can graduate this year. So my mom, I told her that if it's possible, you know, she can help me out still. If she can talk to my counselor to help me out, so that way I can finish school. And so my counselor, she said she was going to talk to the people for Excel, and she was going to get me in to where I can graduate. I only needed 5 more credits. And so that's my plan. You know, I at least want to finish school.
And
You know,
what are your plans after that?
I wanted to go to trade school, go to welding, but when it happened, I stopped going to school, you know, because I didn't know how to feel. I didn't know how to, you know, and eventually, like, I was like, well, I can't just not do nothing. I gotta finish school because that's what
Have
I
you
want.
spoken to your friend after this?
I haven't. I've tried to.
Well, I will tell you this, I've seen many cases where this happens, and then people don't take their friend to the hospital. They just drop them off somewhere, and the person ends up dying, and they're like, oh, we don't know what happened. So at least you did that. But
he did that and then further confessed. He did come back and tell the officer, no, this is the true story. So he has taken responsibility for his actions since day 2. Not day 1, but day 2.
all right, when's the last time you smoked?
Probably since I've been in jail for 3 months, so probably like last day that I've been in here.
And how has jail been treating you? Do you enjoy jail?
No, ma'am. No, you're
I don't know anybody who does. All right, this is what the court is going to do. With regards to placing you on probation for 10 years, I'm not going to do the full 10 years because these are young children being dumb. I am going to give you 6 years deferred adjudication. There's be no possession of firearms. There's a $1,000 fine to be probated. I need a 30-day reset for restitution hearing. State, if there's any restitution, you need to provide it at that time. All right, so August 20th will be for a restitution hearing. They're going to give you a reset form. There's going to be regular reporting by Zoom or in person, regular UAs, 300 hours of community service restitution. Ms. Abrams, do you think that MRT, I don't think this is an MRT thing. I think this is children having guns and being stupid thing.
Judge, there's a copy of the behavior course and then you will then safety course.
All right, so I'm gonna order the gun safety course. And once that's completed, 50 hours will be deemed satisfied. 50 hours will be deemed satisfied upon completion of the cognitive thinking course. Your remaining community service hours, which is 200 hours, will be deemed satisfied. And this is not a requirement. Here's the thing. You can either work in the heat with your 200 hours community service restitution, or either you obtain your GED or some sort of trade school certification, the court will deem that satisfied. Have you ever had any type of employment?
Yes, ma'am.
All right. Ms. Abrams?
Just while she's working on that, the gun safety course,
Just 1 second. Ms. Abrams, I don't know why it's not. You want me to repeat that? All right, so, Ms. Abrams, I'm not requiring him to work. He needs to concentrate on his education, but if he obtains employment, there should be no employment as a home health care provider or with minors. I'm gonna want field visits 1 time per month for 3 months. Does his friend want to have any contact with him, or is that relationship over?
I don't believe there's, I mean, I don't believe there's any.
He does not.
I bet the parents don't want anything. I don't think there's any animosity, but Mr. Prater would know better than me.
Mr. Prater? Do you know if the complainant wants to have contact with him or no?
No, Judge, there is no contact quantified.
Then
All right,
we're fine with that.
that relationship is done, okay? So there's to be no contact with Christian Salazar. Probation, is there anything else? Is there anything you need from the court to be successful?
Judge, one last thing, and forgive me, I've never gone through a gun safety course. My concern there is that he would violate his conditions of probation.
I don't think they don't give you guns.
They don't,
No,
okay, making sure.
it's just more educational.
Fine with me then.
Things like the most dangerous weapon is the unloaded weapon, because you really don't know it's unloaded. Don't point a gun at somebody unless you're intending to use it. I'm not going to get into if you point a gun at somebody and your life is in danger, what should you do? But all right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And you need to really think about what you did, okay? You'll probably be released at 1 a.m. Oh, I'm sorry, Miss Abrams, do we need a TAP evaluation?
Yes.
All right, we'll do a TAP evaluation out of custody. Follow recommendations. If the TAP recommends inpatient treatment, we'll start with outpatient. All right, make sure you make all the appointments, okay?
Yes, sir.
All right, good luck to you.
Thank you, Judge, may I be excused?
Yes.
Who's on this?
Who's here on Gilbert Martinez Ramirez? Where's the attorney? Sorry, your attorney's not here. You may want to call them.
No, take it right now.
I'm sorry.
All right, thank you. And let those attorneys know this afternoon.
No.
Anyone else ready?
Judge,
Okay, what page you have to sign in?
I did, Judge.
All right, then it's gonna go in the order of appearance.
Page 4, the left one.
Megan Potnick. Hello.
Hi, Judge.
Hi. All right, what's happening on this?
Judge, we have, I guess, a tentative approval from ADA Rick Pena for my client to go to felony mental health court. And so we'd like to receive a referral to that today, please.
She can begin the application process for them.
All right. Norma, do a referral to mental health court. Yes, sir. And recall this in 30 days. All right, once you sign the reset form, you excuse.
Thank you, Judge.
You're welcome. And counsel, make sure your client is med compliant because they will not be accepted if they're not.
Okay, Judge, thank you.
You're welcome. All right, who's next?
This is actions on page 4, on page 6, 4 down.
Catchings.
I'll make her sure.
Here, but
All right, just have a seat. We'll call you up when your attorney comes back. Who's next?
but it's on page 1, 5 now.
Dwayne Griggs. No. We'll continue. We'll bring it. When he comes in, just have him come forward. All right, y'all are set for jury trial.
We are, Your Honor. Just for the record, I'm here, Rep Parr, on behalf of Matt Allen, his attorney of record in this case. There's been an unopposed motion for continuance filed. The court appointed an expert in the beginning of June. And so the continuance is an ask for an additional 45 days so that the expert can be ready, be here to testify and complete his investigation.
And where's Matt Allen?
His kid had a doctor's appointment today, but he did confer with the state before coming and I brought his unopposed motion for continuance.
Are you Mr. Griggs? Yeah. All the way to the front.
All right, on this matter, you all need to have to the court on Dr. Fabian. When is his report going to be due? Just saying this 45 days is not sufficient. So if you all call Dr. Fabian, and I want to know when he's going to be available and when his report is going to be completed.
Understood. I'll give him a call. And then do I need to reapproach or speak with the coordinator?
Oh, just reapproach after you've done that.
Okay.
Thank you for dressing
Your
appropriately for court. Just have a seat and we'll take you up, okay?
Thank you.
All right, who's next?
Mr. Noah on page 11, 5 down.
All right, this is a motion to revoke, so I need the motion. And it's 2 motions, I believe. Noah Alvara, are y'all ready on the motion to revoke? His attorney's not here.
On Veda?
Yes.
Yes, Judge, we're gonna be asking for a reset on that case.
For what point?
We're trying to obtain some evidence, the new number ones that are listed in the MTR, conferred with the state and with probation, and I understand that there's no objection to a reset.
All right, state. Are you all gonna have are the drug tests in or no?
I haven't looked about that, Judge, but I can give me that.
Sure. Hi, how's it going?
All right, Judge, how about yourself?
I cannot complain. It is fabulous. I'm enjoying life.
Say the same, Your Honor.
Oh, that's good.
Yeah.
How's your mom doing?
She's doing good. She's doing good, you know. She's trying to slow down, I think, but I'm keeping her busy. She always complains to me that I'm keeping her too busy. But I'm like, I need help. So how about yours, Judge?
Oh, awesome.
Drug tests have been received, Judge, they just haven't been filed, so I'll get right on that, but my understanding is there's some other evidence regarding the co-defendants, the defendants trying to provide.
All right, Norma. And probation on Noah Alvara. Set this for 45 days for a contested hearing. And if it's not going to be contested defense, you need to let probation know 2 weeks in advance, okay?
Yes, Your Honor. So in 30 days, Judge.
Yes, Noah Olvera, come forward. What date?
September 8th.
All right, so you're gonna come back on September 8th for a contested hearing. And let me prepare you for your September 8th date. I am gonna require that you get a drug test on that day. So you need to come to court clean, you understand? All right, thank you for dressing appropriately for court. Once you, just have a seat, once you sign the reset form, you'll be excused. All right,
Thank you, Your Honor.
And I'll see, sir.
All right. I'm gonna say, Judge,
All right, you too.
maybe excuse.
Yes, you may. Oh, come on, just give me one moment.
You bet. Busy in here. I can't spell.
I'll search.
All right, yes.
I believe the report will be done by the end of August, so say August 31st and ready by beginning of September.
All right. Dwayne Griggs. All right, Norma, set this for jury trial at the beginning of September. What date? All right, September 1st is going to be your jury trial. Your expert will need to be ready. Cindy, you ready? Yes. Court is calling 2025 CR 009253 State versus Dwayne Griggs. Can I have parties announced?
Jeffrey Wright for the state.
And Rep Parr appearing on behalf of Matt Allen for Mr. Griggs.
Are you Mr. Griggs? Do you have any objection to this attorney appearing for Matt Allen?
No.
All right, defense has filed a motion for continuance stating that their expert needs more time to prepare their evaluation. State, are you opposed or unopposed?
Unopposed.
All right, the court will grant the motion. This is going to be set for jury trial on September 1st. And you all need to be here at 9 a.m.
Thank you, Your Honor.
All right, is there anything else?
Nothing for the defense.
All right, once you sign the reset form, you'll be excused.
Thank you, Your Honor.
Thank you, Judge.
All right, who's next?
On 8 down.
Thank you very much. Y'all have a good one.
You too. Jacob McCumber. Hello. All right, court starts at 9 a.m.
Yes, ma'am.
If you're not here at 9 a.m. again,
Yes, ma'am.
there will be a warrant
I was
issue.
just trying to find a courtroom. I had trouble finding it.
Oh,
Sorry.
here's the thing. You've been here before. So, yes,
Oh,
August
using-
1st.
Using trustee.
I'm sorry, not August 1st.
Yes, yes.
Uh,
This is my first.
July
time.
1st.
Yes,
So that was when a bond was set and that was with Judge Keesler.
yes, yes.
So make sure you're on time. You
Yes,
understand?
ma'am.
All right, where we are in discovery.
Judge, I think we're good in discovery. I just gave the state some additional evidence. They need to look into that. So they're asking for a reset to reach out to complaining witness on the case.
All right, were you able to tender an offer or no?
Offer has been tendered, Your Honor. Yes, Your Honor.
All right, how old are you?
26.
All right, Norma, set this for a plea deadline date in 30 days. All right, what you sign the reset form, you'll be excused.
Yes, ma'am, thank you.
You're welcome.
You can go and see.
Thank you, Judge.
You're welcome. Who's next? On who?
Yeah, I signed this.
Hutchins.
Yeah, I know we got to.
Judge, you're all, Helena Catchings?
Yes.
Yes, Judge. Ms. Catchings?
All right. Where are we on discovery?
We had a discovery issue. I talked to Megan. We gave Megan a hard drive. She's gonna have a paralegal download everything onto the hard drive. However, Rick just informed us that the family violence case has a sealed abandoned endangered child case and that they are working on. So we need some time with these cases.
All right, Norma, I need a discovery date, 45 days.
September 8th.
All right, once you sign the reset form, you excuse. Do you have any questions? Any questions? All right, we'll see you back on September 8th.
Thank you. And Judge, I had one more.
Who is it?
From Dennis Johnson, page 11, 4 down.
Dennis Johnson, that used to be Mr. Cox's client.
Really?
We would always talk about the fact that he played for the Celtics.
Oh, wow. Oh, wait.
Oh, not Jordan
Wait,
Knight,
wait.
but someone else named Joe.
Yes.
That's a way back.
Yes.
Did you sign in there?
All right. Dennis Johnson, come down. So I see we have pending
There's,
charges.
right, I spoke with Megan. There's a cell phone dump on one of the ag robbery. The ag robbery is the most serious case. Before Megan is gonna make a recommendation or perhaps an offer, she needs to look at a cell phone dump that they started, but she doesn't have the cell phone dump yet.
All right. Norma, recall this for September 8th.
Thank you, Judge.
All right, we'll see you back on September 8th.
You can have.
Ms. Abrams, this case is being recalled for September 8th. It's not a contested, it's because there are other cases that are pending. Dennis Johnson. All right, anyone else ready?
Yes, Your Honor.
What page is he on?
This individual had, his most serious case is the DWI,
7.
Salvador Garcia.
Oh,
His most serious case is a DWI. And I just found out from the DA that it was a very high back, and I need to get the discovery, and I was gonna Zoom him on Friday. I think I'm off on Friday from court.
State, where are we on discovery with Salvador Garcia? All right, do you have all of the discovery on the DWI?
I will by Friday. So I can talk to him intelligently about any kind of plea. So I'm requesting a reset. It's our
All
first
right, did
setting.
you get a offer?
Yes, a cap offer, so
All
I
right.
need to look at it.
All right,
See if I can
Norma,
advise.
set this for 30 days for plea deadline date, and counsel, if you want your client brought over sooner, just let us know.
Thank you very much, Your Honor. I'll just point you, do I need to separate? I'll wait for the email. Thank you. May I be excused, Your Honor?
Yes.
Thank you.
Wait, can I have it really quick?
All right, just give me 5 minutes. Well, really like 2 minutes.
Hold on, I had a Eric Williams on the docket, right? Well, Eric Williams. Robert Sherman. Didn't even get any notification, but I got a notification in court. Yeah. He is. Okay. So I just got a phone with him. He said he bought it out, didn't know he had court today. He's gonna start making his way over here now, but he probably not gonna come in. Probably because his dad needs to pick him a ride, but I won't be here this afternoon. I won't be now. Sure, when does she issue marks? Might make it back there. I'm not sure I like the dirt bureaus, but. Do I need to put on her radar or no?
Yes. Okay. I don't know, I think more of it.
Yes, it will. You can sign in clipboard too, right? Number 4. Get out of my boat. Get out of my boat. Pressure. I'll go for more close. You must have smell.
Especially.
Yeah, this one, yes. So the other thing. Originally called it. No, it's still that been figured out. Oh. I haven't figured anything out for a while. It's on the ones that are still part of it. I don't think so. David says something. It's so wrong. I saw it.
Oh, okay.
Okay, so this is what we're down here.
It's good to have around.
Yeah, when I'm ready. Think that. No, I like them when he moves cases.
All rise.
Please be seated. Who's ready?
Page 5, 4 down.
So did you say page 4, 5 down or 5, 4 down?
Page 5, 4 down.
Okay. I don't have an Antonio on here. Oh, Antonio Lazard. Okay.
Yeah.
Yeah, that's me. He's the one on Zoom.
Yes. All right, Mr. Lazard, you need to unmute and start your video. I appreciate the tux though.
Thank you.
All right. All right, let me see what's happening here. All right, so where are we on discovery and everything?
Regarding the discovery, Your Honor, I think I'm still requesting a couple more videos. There's like 4 co-defendants, so they might have put them in the other parties' discovery and not my client. I've spoken to the state and they're gonna look into that.
All right, state, are you able to provide the defense, because I think they're entitled to it, the information from the other co-defendants?
So that's what I'm trying to do. The issue is that I just need a little bit of time to do it because the other co-defendants, some of the discovery came over on our new e-discovery system and some's on the old. So I'm gonna get him that information.
All right, thank you. Norma, recall this for September 8th, and sir, you can appear by Zoom.
Thank you, Judge.
All right, thank you.
Discovery?
Yes, discovery. All right, Mr. Lazard, we'll see you on September 8th, and you can appear by Zoom.
Yes, thank you, Anna.
All right, thank you. Yes.
I'm not gonna try to pronounce his name, but it's on page 1, 2 down.
Okay, let's see, is this Spanish and you
No.
guys? Oh, yes, so what is happening in Mahmood?
Good morning, Your Honor. I have reached out to the defense attorney that represents Mr. El Gadrab out of Hardin County. His name is Ryan Gertz. I attempted several times over the last few weeks since our last setting to get a hold of them. They finally returned my calls and emails this or yesterday. I just realized how short this week was. Yesterday, informed me that Mr. Gertz is out of town on vacation, submitted a vacation letter with the court out in Hardin County. Gave them that information, so they were still holding a hearing today for Mr. El Gadrab in Hardin County, but did not require the attorney's presence as they were, I guess, setting up a reset. The paralegal that I spoke with at Mr. Gertz's office said that I guess the main courthouse in Hardin County is under construction, so they are in a smaller courtroom with no, I guess, electronic capabilities. So I asked them about me providing them with our court's Zoom information, and they said that they couldn't do that. I reached out to the court and they confirmed that as well.
Well, is the defense attorney able to do Zoom on, nobody can do Zoom on a cell phone? Nobody has an iPad, Wi-Fi?
Well, the defense attorney is not there in court.
No, I mean, on a different day.
Oh, on a different day, potentially, but I don't know when Mr. El Gadrab is going to be reset. Because he was scheduled today to be in court. So I don't know when his reset date was going to be. But potentially, yes, because that was what I was trying to coordinate, was to have the defense attorney use his personal cell phone if needed to coordinate the Zoom.
Let's see if you can coordinate with the defense attorney.
Okay.
And what I'll do is I'll recall it for September 1st.
Okay.
But if you all are able to get it done sooner than then, just set it and let us know and we'll do it by Zoom.
Okay.
But just not the week of August 18th, not that week.
Not, okay, we'll do.
Okay. All right, so we'll do September 1st.
September 1st for now. Okay.
All right, thank you.
So I'm excused.
Yes.
Thank you.
Norma Algadrop reset for September 1st. All right, who's next?
Jacob, they're doing, and
All right, Jacob Harris.
oh, wait.
Could I have a file snap, please?
Yes.
Oh, thank you. All right, are you all ready to proceed on the motion to revoke?
Yes, sir.
All right, the court is calling 2021 CR 5266 State versus Jacob Harris. Can I have parties announced?
Brandon Prater for the state.
Angela Blake, attorney, Mr. Harris.
And are you Mr. Harris? Did you review the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney, and did you understand it? You need to speak up so the court reporter can hear and so I can hear.
Yes, ma'am.
All right, are you the same Jacob Harris who was placed on deferred adjudication in 2021 CR 5266 for the offense of evading arrest detention with a vehicle on April 14th, 2022 for a period of 2 years and extended for a period of 2 years? Is that you?
Yes, ma'am.
All right, state.
Judge will be proceeding on a violation of condition number 4, specifically that in Berry County, Texas, the defendant, Jacob N. Harris, did then and there fail to report to the supervision officer as directed for the month of August, September, October, November, December 2024, January, February, March, April, May, June, July, August, September, October, November, December 2025, January and February of 2026, in violation of condition number 4.
How do you plead to that? True or not true?
True.
All right, state.
Judge waive the remaining allegations.
Any objection?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is not, Judge. We're being open to the court.
All right, state, what are you requesting?
Judge, because the defendant has numerous violations and has basically been absent from probation for about a year and a half, Judge, we'd ask that you revoke the defendant and sentence him to the maximum of 10 years.
All right, defense, what are you requesting?
Your Honor, I'd like to call my client.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jacob Montreal Harris.
All right, you may proceed.
Thank you, Your Honor. Mr. Harris, what are you asking the court to do today?
To put me back on probation.
Why do you believe you deserve another shot at probation?
I wouldn't say I made a mistake. I made a bad choice. Making stupid choices. I'm bettering myself. I just want to be there for my kids and be there for myself. Do right.
Part of that time that the court alleged, and you have also pled true, that you were not reporting to probation. Were you actually in custody somewhere?
Yes. Yes.
Okay, where were you in custody?
In Florida. But
I'm sorry, I can't understand a word you're saying. Are you?
I was in custody in Florida, but that was just recently. Before I was not in custody. I didn't report.
So what was he doing? I'm sorry, what was he doing in Florida? Because did he receive permission to go to Florida?
No, ma'am.
What was he arrested for in Florida?
What were you arrested for in Florida?
For charges were dropped, but I was arrested for false identification and I forget the other charge.
And what proof do you have that the cases were dropped?
I have full proof. They dropped the charges. Charges I was under sitting for like a month and a half. They dropped all the charges and I was extradited over to Berkeley County, Berkshire County.
Did you have permission to be in Florida?
No, no.
But you're asking the court to give you another chance at probation, correct?
Yes, ma'am.
Is there anything else you'd like to tell the court as to why you believe you deserve to have another shot at probation?
I just want to say, my apologies for wasting your time.
Oh, here's the thing. Nobody is wasting my time. This is what I get paid to do.
Yes, ma'am.
But what I can tell you is this is your third motion to revoke, and each time you're not reporting. So I can tell you, you're not being continued. And then now I discover that you're in Florida. You're not supposed to be in Florida. And when you first had a motion to revoke, it was in 2022, and it was a violation of condition number 4. And I allowed you to transfer to Coppers Cove, Texas, Coppers. Then another motion to revoke was filed in 2024 for not reporting.
Yes, ma'am.
And at that time, you wanted to transfer to Clayton County, Missouri. I allowed that. And then now we're here and you said, oh, I have children. I want to be there for my children. And then now we're back here for a violation of condition number 4. So the court is going to revoke.
Yes, ma'am. Can I say something?
Sure.
I would like to say, both of the time that I was transferred to, where I got my probation transferred, it was not a set home for me. One of the homes in Coppers Cove, I ended up getting to the person that I was staying with. They didn't want me there because of what I was going through. My mom, she stays in Shatter, Nebraska. I have the address. She said she's.
But is she in Florida? Who's in Florida? Why were you in Florida?
I was in Florida because I was going down there for work. I knew a guy. I was working down there. That was my only resource at the time. But
you sure are able to travel from place to place with no resources. Do you see you, Bear County, then you're in Coppers Cove. I don't know what the distance is from here in Coppers Cove, but I believe it's more than 30 minutes. Then from there, you're going to Missouri. Then from there, you're going to Florida. Yeah, I'm granting the motion. I'm going to find you guilty, give you credit for any time served. There's to be no contact with Adam Campos. Court is going to sentence you to 5 years in the prison. There's to be no unsupervised contact with minors and no residing in households with minors. And I'll request the therapeutic community and counsel if there's some time where he was in custody. He's saying it was a short time, not for the years that he didn't report. Just let the clerks know and they'll give him credit for that. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. All right, good luck to you.
Thanks.
You're welcome. Who's next?
Mr. Blake on page 4 down.
All right, that's a motion to revoke.
Oh, Judge, you have a Bluetooth pairing request?
I'm sorry, what?
Go to the Bluetooth pairing request on screen. Thank you.
Okay, thank you. All right, who is this? Blake McCloy. Where is he?
Coming up.
All right, and why are you asking me to withdraw this?
Yes, Your Honor, this defendant missed a compliance hearing for his medications. He was on prescription medications and he was required to attend compliance hearings back in June of 2022. His probation expired on July 30th of 2022. He apparently believed that he was good at that point. And he's committed no new violent offenses in the time since that. So the state at this time is recommending that this court terminate the defendant unsatisfactory.
All right, so here's my question.
Yes, Your Honor.
The allegations in this motion, it's alleging that he didn't have gainful employment. So has he obtained employment?
Yes,
yes.
All right, and where is the proof of that?
Mr. Goss. Well, would you be able to provide it?
We could provide proof. He
All right,
worked in.
provide the proof. And then with regards to the compliance hearing on here, it says there was supposed to be a compliance hearing on June 16th and June 23rd. So
Yes.
why were those missed?
It was 4 years ago. He believed that his probation was over.
All right. Well, it says that he was on probation for 5 years.
Years. Yes, Your Honor. This was the week before his probation expired.
All right, so he had a compliance hearing on June 16th. He didn't show. Did anybody reach out to him and say, hey, you have a compliance hearing on June 16th, you did not show?
Yes, Your Honor, the notes indicate that the due diligence was extended by the probation office to contact him and inform him of those compliance hearings.
All right, and then we had a compliance hearing on June 23rd, 2022, and he didn't show.
It's the same thing. Texts were sent as well as letters at the time. I don't believe anyone made direct contact with him at that.
All right, and then is there any proof of where he lives? Because before I sign motions to withdraw, I want to make sure that the issues that were in the motion to revoke have been addressed.
Yes, Your
So,
Honor. Proof of
where's the
employment.
proof of employment?
Proof of employment and residence. Yes, Your Honor.
Yes. So provide that and we'll take care of it.
Yes, Your Honor.
Thank you.
Are we going to be reset? Because I don't know if we can, I mean, in what
Well,
way would you
let me
like
know
us to
when you
provide?
all will be able to provide it.
Your Honor, would we be able to reset to Thursday?
All right, see you on Thursday.
Thank you.
Okay, thank you.
Thank you, Your Honor.
You're welcome. There you are. Who's next?
Gilbert on page 6, 5 down.
Gilbert? Oh, how's it going? I'm doing great. How are you? Oh, I'm doing fabulous. I cannot complain.
What kind of trial are y'all in?
Oh, it's a murder. Yeah. All right, on this case, where are we on discovery?
Believe that we're in receipt of all of discovery in this case. We conferred for the first time this morning. We received an offer from the state. We'd like to provide some mitigation to the state to see if we can get that changed. So we're asking for a reset to do that.
Okay, how old are you, sir? All right, Norma, set this for a plea deadline date in 45 days. All right, so y'all will need to confer off docket.
Of course.
All right, see you back then. Once you have the reset form and sign it, you're excused. Just have a seat. Your attorney will bring it to you.
Thank you.
All right, who's next?
Jonathan Garza on page 8, the first one.
Jonathan Garza. Hello.
Hello, Judge. Good to see you.
You too.
Morning, your Judge.
Good morning. Y'all are two blurry figures. Let me put on my glasses.
Figures. People tell me that.
Oh, wow. Now I can see everything. All right. So on this case, where are we on discovery?
I believe I have the discovery.
All right. Was an offer tender?
Yes, Your Honor.
All right, sir. How old are you?
I'm 33 now.
All right, Norma, set this for a plea deadline date in 30 days.
August 20th.
All right, we'll see you back on August 20th. Once you sign the reset form, you will be excused.
Thank you, Your Honor. Yes,
Okay,
ma'am.
I have a
Thank you.
question.
Yes,
I've
ma'am.
always wanted to know,
Yes, ma'am.
with the earrings, is that painful when you're doing the stretching and braiding it up?
When you actually go through the process of from little to small, there's no pain. But if you're just going from little to big, there's pain.
So let me ask you, when you first start and you're doing it, is it just like a small piercing
It's
like
like
I
a
have?
piercing now.
And then you just keep,
Little by little, it keeps getting bigger.
Right.
But there's oils to it too.
oh, okay.
This month.
All right, I've always seen, look, I've learned something new.
It's nice to meet you, ma'am.
All right, you too. Have a great day and thank you for dressing appropriately
Thank
for
you, ma'am.
court.
Appreciate you.
Thank you. All right, who's next?
Jeremy, on page 7, 4 down.
Jeremy Cruz? And Norma, whenever their lunch comes, let me know. All right, good morning.
Good morning, Your
All right, where are we on Discovery Council?
Honor. We're all good. They gave me an offer. I need to check something legally and I'm just asking for a 2-week. I don't want a 30-day.
All right, Ms. Ferguson, I need a 2-week reset.
Yes, ma'am. August 4th.
August 4th? All right, once you sign the reset form, you're excused. Oh, no reset form. All right, we'll see you back on August 4th. They'll bring you over.
Thank you.
All right, thank you.
That's fine.
Yes.
That's fine.
Can I get on a list? Is there a list to be?
All right, who's next?
Eric Williams,
Eric Williams?
on page 7, 6 down. I'll be right there with you.
So Judge, Mr. Williams is not here. He's on his way. He's one of the clients I had this morning. I called him at 9:15. He just responded back about 45 minutes ago while I was talking with prosecutors on my other client I had today. He's gonna be here probably the next half an hour. He needs to get a ride. He thought his court date was in September, which was a pre-indictment court date in Judge Naharat's court, but the case got indicted in the meantime.
Okay.
So he wasn't aware that we had a court date on court today, July 21st. He might be here right at noon or for your afternoon doc, but I can't come back this afternoon. So I just really want to put on your radar that he's on his way in.
Okay, and on this case, have you received all discovery?
Yes, Judge, this case is a possession case. I'm also appointed on an ag assault deadly weapon case. So that's what I was initially thought I was here in court for. When I have the client's name, and of course, Rick told me that that one's not been indicted yet, but I did give them an affidavit of non-prosecution on that case. But what we're here today for is the possession case.
All right, we're gonna recall that and we will recall it for August 20th.
Okay.
And just make sure your client is here.
Perfect. I'll let them not come then, Judge?
Yes.
Okay, August 20th?
Yes.
Okay, all right, thank you.
All right, who's ready?
Danny Garcia, on page 5, 6 down.
Danny Garcia? All right, today is plea deadline date.
Judge, state just sent me over some additional discovery that I have not reviewed.
Yes, Your
What
Honor.
is this discovery?
Yes, Your Honor. We'd requested CPS records related to this defendant and his family on May 26th of this year, in 2026. I received an email this morning from my investigator that those received overnight. 256 pages in 2 different reports from CPS as well as some audio. And that has been provided in Axon to the defense.
And see, I know you'll probably be different. I don't understand why family violence cases, from the very beginning, they don't ask for CPS records, school records, all of that. I know you will do that. So I
Yes, Your
appreciate
Honor.
that.
Yes, Your Honor.
All right. This is being called back for jury trial on August 20th. All right. Once
Yes,
you
sir.
sign the reset form, you will be excused.
Thank you, Your Honor.
Yes, Your Honor. Typically, when that doesn't happen in the intake and it gets indicted in the first setting, I see what we've received and make.
And then when you have motions to revoke, and I know you and I have not had a chance to discuss, when people are asking to withdraw motions, I want to make sure that all issues are addressed so that the community is protected.
That makes sense.
Okay, all right, thank you.
Yes, ma'am.
To the clerk, are you able to do a reset form for his client?
Yeah, I can do it. Just give me.
All right, thank you. Oh, you know what? Let me see something. August 20th, just one second.
You're clipboarding him now. Best.
Oh, excuse me, counsel. On Mr. Danny Garcia,
Yes, Your Honor.
it won't be August 20th. Norma, it'll be August 17th. For your jury trial.
Your Honor, any possibility August 24th,
No,
31st?
no, August 17th.
You don't want me to have a good vacation?
Yeah,
No, you take it.
I'm sure it'll be great. It'll be August 17th and then, thank you. All right, who's next?
Juan Mejia on page 3 through the.
All right, and could you put on there that it's for a jury trial?
Yes.
And that's August 17th. All right, Juan Mejia.
He's in custody, Your Honor.
All right.
I'm going up, he's not out yet. He's one of the ones that they can't bring up yet because they have too many in the back. Can I come back sometime this afternoon?
Oh, yes. We'll see you this afternoon then.
What's 1:30?
Yes.
Thanks, Your Honor.
Take them.
All right, who's next? Hey, how's it going, Hunter?
They're already on that one.
And deputy, don't bring anyone outside in the box because we're going to take our court recess in a little bit because everybody needs a break. Alicia Tenoria. Tenorio, where is she? Hi.
Hi, Judge.
You all ready to proceed on the MTR?
Yes, Judge.
Court is calling 2022 CR 3924 State versus, why is this listed as Alicia Lindsay?
She has an AKA is my understanding, Judge.
So what is her true name?
Tenorio, Your Honor.
All right. So the court is calling 2022 CR 3924 State versus Alicia Ashante Tenorio, AKA Alicia Ashante Lindsay. Could I have parties announced?
Lauren Espinoza for the state.
Brent La Paz for Ms. Tenorio.
And are you Ms. Tenorio?
Yes, ma'am.
Did you review the motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same person who's placed on deferred adjudication in 2022 CR 3924 for the offense of criminal mischief, $2,500 to $30,000 on August 30th, 2022 for a period of 3 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 2, on or about the 5th day of April 2026 in Bexar County, Texas, the defendant Alicia Ashante Lindsay did then and there fail to submit to drug testing as directed by the court officer, supervision officer, and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True. State will waive the remaining.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 2? Just one moment. The court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, sir.
Court will find violation of condition number 2 true. Is there proposed agreement?
Yes, Judge, the proposed agreement is to deny state's motion, continue, alter, and amend for a 1-year extension to allow the payment of restitution and continuance with UAs.
All right. Is that the agreement?
That is, Your Honor.
If you're drug tested today, what are the results going to be? And know that you're going to be drug tested today. You're getting drug tested today.
Okay.
All right. What are you going to be positive for? And what else?
That's it.
All right, Miss Abrams, when's the last time she had a TAP evaluation?
I can tell you, Judge, that, she's tested, consistently negative, and then there was a positive back in 2024. There was a positive in February of 2026. And then there was the failure to submit, and then the one after that was negative. So she's only had, well, not only, but she's had 2 positive for marijuana only. There's not been any other substances.
All right, how much is she on restitution?
$4,036.34.
When are you gonna be able to pay that?
If given the extension, I can pay it before then.
No. When will you be able to pay $4,000 and, I'm sorry, how much?
$36.34.
The person has been waiting for that to be paid since 2022. So you want to discuss with your attorney when you'll be able to pay that? Because I can tell you what I'm going to do. I'm going to accept your plea of truth, not going to make a ruling on it, and you're going to pay that $4,000. So when is that going to be paid?
So that's what we discussed, Your Honor. She does have family here.
All right, discuss it with the family and see if you all can pull some money together to pay this $4,000. If that money is paid, then the court will consider terminating your probation. You'll be done.
That's what
Now, that restitution is due to Bear County risk management.
All right.
So Your Honor, the understanding with a payment plan is to pay this off in 10 months, which would be before the 60 days before the extension would be.
Tell you what, pay $2,500 towards that. Come in with a negative UA, and I'll terminate your probation unsatisfactorily. So you may want to talk to your family and see when you can come up with that $2,000, but it's not going to be a year or 10 months.
Yes, Your Honor.
So y'all want to discuss
Yes.
that and come back to me with a date?
Yes, Your Honor.
Thank you.
Thank you, Your Honor.
All right, who's next?
Robert Rodriguez on page 4, on page 5, 4 now.
You say page 4?
Page 5.
Oh, I'm sorry. Robert Rodriguez. Robert Rodriguez. His attorney is not answering. Warren Wolf.
Yes.
Robert Rodriguez, you signed. What's going on with Robert Rodriguez? All right. You know what, Deshaun? In the words of Sanford and Son, you remember the Sanford and Son with the postman? And they would ask him questions, and he's like, I don't know. And then he would tell him, how many people will tell you honestly that they don't know? We used to always love when the postman would come on. All right, if there's nobody else that's ready right now.
We have a reset.
All right, so don't put anybody else on the check-in because we're taking our recess. So anybody who's here now and you're ready to go now,
We are ready.
I'll take you up. Otherwise, we're taking a recess.
Dennis, Mr. Morgan,
Who is it?
Dennis Morgan.
All right, Dennis Morgan.
Line cutter you.
Oh, I'm sorry.
Age before beauty.
Definitely.
Hello.
Hello, Judge.
Hi, Hunter. It's always great seeing you.
Likewise, Judge.
All right, so where are we on discovery?
I believe discovery is complete at this point, Judge. This is a first appearance, I believe, on this case. We have contact with our complainant. Our complainant is currently in recovery from a leg injury. So defense and I talked about the case, and we're following up with the family to inform them of the offer that I have in mind prior to extending it to comply with the code, Judge.
All right.
And the lady is 88, complainant's 88 years old.
All right, Norma, set this for a plea deadline date in 45 days.
Okay.
All right, once you sign the reset form, you'll be excused. Thank you for dressing appropriately for court.
Thank you, Judge.
And if there is some type of restitution, he needs to come in with funds.
There is no restitution.
Okay, awesome. Thank you.
Yes, ma'am. Thank you. You say September 8th? Is that what I heard?
Yes.
Perfect. Thank you, Judge.
All right, who's next? Charles Bach?
I will be.
Who do you have?
I have Mr. Kamar Simpson first.
All right, let me find what page is, yes. Tamar Simpson. All right, here's the thing, court starts at 9 a.m. You understand? Do not be late again. If you're late again, what's going to end up happening is a warrant is going to be issued. And you may not be on time for court. It'll depend on when they bring you over from the jail, okay?
Yes, ma'am. I'm so sorry. I came in at 7:05, and then I asked somebody downstairs, and I think they pointed me downstairs, and then somebody, right officer was upstairs. But
Yeah, well, now you know where it is. There are no further excuses, okay? All right, where are we on discovery?
We're getting there. I'm relatively new with Mr. Simpson.
Mhm.
He has a case that was just indicted within the last month, so I'm getting the discovery on that. So he and I have been conferring with the state as well, so we can.
And that's the
proceed.
marijuana, correct?
Yes, Judge.
All right, and then he has a motion to
A
revoke.
motion to revoke, right?
All right, Norma, set this for a contested MTR in 30 days.
Okay.
August 20th.
Sure.
All right, August 20th. Once you sign the reset form, you'll be excused.
Thank you, Judge.
All right, thank you.
Will you get him to sign that? I have one more with you, Judge.
Sure, let me listen.
Okay. Good. That's fine. I'll do it. Come in, please. I got it.
All right, who's your other person?
Derek Lopez. Today was our plea deadline, Judge. They've made us a new offer. I'd like to set him for 30 days and we're gonna come back and accept an offer. We have a real plea on that for a plea date.
All right, Derek Lopez. All right, Norma. Set this for disposition in jury trial. So either it's going to be jury trial or a plea in 30 days. August 20th. All right, August 20th.
August 20th. Okay, perfect. Thank you.
Thank you.
Have a seat. We'll resign it. Thank you.
Can I give you an update? And
yes,
you.
Charles, and you, I think that's the last one you have. Just give me 1 second, counsel. Norma, doesn't Charles have somebody else on the docket too?
That's 2 more people in the different judge.
Okay,
On or before the 18th of August.
all right, Norma. On Tenorio. We need to put that before August 18th. Because I'm not gonna be here August 18th.
Okay.
And I think you would rather I hear it.
I can do the week after, Judge, but I was just trying to get a sooner date.
Okay.
Want to do the 13th, Judge?
13th, is she able to have that by the 13th?
What page is she on, Judge?
She's on page 12.
Yes, Your Honor.
All right, so we're recalling on August 13th.
Okay, thank you.
Just give me a moment.
We'll come back and do it.
Are there any other resets?
No, ma'am, just have two more left on the list.
All right, then after I take these up, we're taking a break. What date did we give Dennis Johnson?
We're set that.
No, what date?
9/8.
9/8?
Prisoners that are employees, when they come back and do this afternoon, what time?
What time do you want them back this afternoon?
Like 2?
Yeah. We'll be here, we can't be.
Charles, we'll say 2-ish.
Okay.
Back to 2:00 and do the consult.
Gilbert Ramirez. After we take this case, the court is going on recess. And we'll see everyone back at 2. Court is calling 2026 CR 004539 State versus Gilbert Ramirez. Can I have parties announced for the record?
State.
Michelle Acevedo for Mr. Ramirez.
And are you Mr. Ramirez?
Ma'am, I am.
Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, ma'am.
And counsel, have you received all discovery and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ramirez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading?
Yes, Your Honor.
State, are you proceeding as presented?
We are, Judge.
Mr. Ramirez, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with theft, less than $2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is, Your Honor.
Mr. Ramirez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, there's a $1,000 fine probated. State recommends deferred adjudication. They're taking consideration 2026 CR 004546. Did you understand that to be your plea?
Yes, ma'am, I did.
State defense?
That is the plea, Judge.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Council, any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There be 100 hours community service restitution at the DOEP course, felony theft course, and regular UAs. Did you understand those were recommendations from the state? And the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Judge offers exhibit number 1, including all attachments.
No objection, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, we would just ask that you follow the bargain.
All right, why do you keep stealing?
Hard times, ma'am.
Well, I mean,
Hard times, really, really hard times.
well, you're
Right now, I'm having a situation where I've been here 4 times. I know it's not just my fault, but the parking is $12, and that's a whole week for me and my wife to eat. And it's 3 times I pay $12, and
So
right
what are-
now I don't
what-
even
What are
have
you
the
doing
money.
with the clothes that you're stealing from Walmart?
Well, I'm selling them, to make money off them.
Well, here's the thing, you can't go around stealing because guess what?
I realize
Everybody
that.
has hard times. And if everybody decided they're having a hard time, so let's go steal, then where would we be as a society? There are plenty of places. You can go to the Salvation Army. You can go to these different organizations and they give you clothes for free and they will help you with food. Now, I don't understand why people say my pride is too great for me to go someplace, but then we steal.
Yes, ma'am,
Oh.
I've been to the food pantries, and I've
That's okay. You did it gracefully.
yeah.
All right.
I go to the food pantries and they give me a box, that box. I mean,
Here's the thing, if you go to Blessed Angels Community Center,
It's
they
all-
have a food pantry. They will give you full meals. Some of their meals are cooked, some are not. I've been to Blessed Angels Community Center several times. They are really there helping seniors. They make sure you have everything from the food group. I know people don't do the food group anymore, like when we're in school, you have the triangle with the charts. I still believe in that chart and I follow it. But they will make sure you have your vegetables. They will make sure you have your meat. They will make sure you have your dairy. They give you all of that. And guess how much they charge you? $0.
That's in there.
And guess what else? They will give you clothing. They will during
Some of their
the,
clothing they give me.
yes, and during the summer months, they will have fans. They will have even those little portable AC units. They give you all of that. So there's no excuse to steal. And if you can find your way to get to Walmart to steal, then you can find your way to these other places. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be no contact with Walmart. So you're going to have to go somewhere else.
No, ma'am, not going nowhere else.
There's to be regular reporting by Zoom or in person. There's $1,000 fine. That's to be probated. Proof of employment or SSI within 45 days. No employment as a home healthcare provider with minors. Take in consideration 2026 CR 004546. And is that another theft case?
Yes, Judge. And I'm sorry, that's a possession case, and that's going to be TIC by the state.
All right. Possession of what?
Methamphetamine.
Which was when it wasn't methamphetamine.
All right, 100 hours community service restitution. I'm going to order the felony theft course. Once the felony theft course is completed, the community service hours will be deemed satisfied. Field visits 1 time per month for 3 months. And probation, if you can see, if you all can give him more resources for him to sustain himself. And probation, is there anything else?
Did you want to do UH, Judge?
Yeah, we'll do regular UAs. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? With your attorney, did you understand it and sign it?
Yes, ma'am, I did.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And Ms. Abrams, I'll add no possession of firearms as well. All right, good luck to you.
Thank you, ma'am.
Thank you, Your Honor. May we be excused?
Yes. Oh, Rochelle,
Again.
here's this.
Big up.
Thank you, Judge. All right, we're going on recess.